So it has to go there.
No, whether it will.
Not disposed one.
Huh?
No,
Both are pending.
both are pending. That is listed today there, and one is listed here, arising out of the one PS. But
What do you want? I said.
I don't want anything. I just brought it to your lordship's notice. Anything, but I think it should be heard by one bench.
That's always better.
Because that is what, that is the old law also, that is what your
No,
lordship is.
this is arising out of the same.
One PS.
One PS. Right.
I am also appearing today on behalf of the informant today by filing Okaladnama.
No, who is
Petitioner is somebody else, the Mr. B. Mishra.
Let him come.
My lord.
I'll send it there.
My lord.
Yes.
I am also appearing on behalf of the informant today.
I'll send it
I'm
there.
here, ma'am. I am here or my associate, my.
My file may be deleted.
Say guess.
No, I was appearing for the informant.
Okay.
Power to delete it, तो फिर मुझे कौन सा
It's all right. Yes. Next mentioning.
No, not.
Notary compromise, my lord. Your lordship,
What is the offense? What is the offense?
postcard. Rosal is often covered by your lordship.
When you
Rosal
come, you just give it. Come.
next week, my lord, Monday, my lord.
It will come. Yes.
Today list item number 97. Another CRLNC was filed for the husband lordship. Meanwhile, the matter was compromised. My senior is appearing for the opposite party.
46.
I pray the both along with
And what is the offense?
490.
Okay. Give the number listed on 20.
My lord. But
Give that number.
my lord, I will.
Yes, madam.
I today list item 101, my lord. I am appealing for the opposite party number 2, my lord. It's taken up next week, my lord.
Maybe who is her petitioner, ma'am?
Pranay Kumar Dasan, I have already informed, my lord.
No, then he will come and complain. That's the problem. Okay, you tell, huh? Oh,
Okay.
urgent.
My lord. Item 19, not press.
Huh?
19.
190.
Again, not press.
Not press. 90.
Oblast, my lord.
Not press. Huh?
May I request,
Yes.
Lord?
Yes.
Item 110.
110.
Other day, it was a vigilance matter. Other day, Lordship was directed to take a fresh admission. It is a case where gas it was supposed to release. Sangram Das was appearing in this case.
Yes.
So may I request me Lord to have some difficulty after lunch. So may I take after admission 6.
Note karo ko urgent karo.
6 for a 6 item for fresh admission. For it, can I?
Yes.
pray?
I note it down. I'll let.
Then the other day, he was taken instruction. Also, I have instructions. Some
Okay, it's all right. I'll accommodate.
Oblast.
Yes.
Milord, am I audible, Milord?
Yes.
Was 101 mentioned just now?
101. Yes.
just mentioned
Yes. Yes. 101. Mr.
I am appearing for the
101?
petitioner. Yes, yes.
And the council already taken time.
Who is?
That's all right. What I am only suggesting is, Milord, if your lordships direct the state to produce the case diary on the next date, Milord, this matter can be disposed of.
101 case diary. Come on, no? Case diary. You are in the 101.
That young lady has mentioned.
Yes. Yes.
That's
Then
all
I'll call
right.
for
Would
proceeding. I'll
your
call for
lordship fix a date, Milord?
and you
First
tell
week
me
of-
which date suits you. Tell me so that I can.
First week of October, Milord, any date.
First week October. No? After 3. After 3rd. Okay.
Grateful, man.
I may be pardoned to make a mention, Your Lordship.
Yes.
My Lord, item number 3 of today's list, my Lord. My Lord, we have
3.
sought, yes, my Lord, we have sought for certain documents from the learned code below any day, first week of October, my Lord.
3 will come within 3 minutes. Please wait.
Your Lordship.
Please wait. Yes.
Pardon to mention, my lords.
Yeah.
Mr. Parijan on the online, my lord, that entry matter to continue.
Entry mode will continue. Entry mode to continue. Yes.
Pardon to mention, my lords.
Yes.
Item 82 has become infructuous. I have filed a memo for a withdrawal of the case. Item 82.
Withdraw. 82 withdraw. Thank you. Thank you very much. Yes. Yes, sir. Do we mention, huh? Yes. Yes. Give me one copy.
Your lords, the thought facts of the case. Petitioner was formerly the managing director of the company. There was an incident in which a contract worker died. We immediately paid the compensation.
Who is the occupier?
Occupier is the present petitioner. He is the deemed occupier, being the managing director of the company.
Okay.
Under the provisions of the Act. So we immediately.
You show me the limitation.
Limitation, I'm saying, first of all, your lordship, kindly see my note. We have already paid him the compensation.
No, that's a different thing. The prosecution. I'm talking about prosecution.
106.
All these things are on the question of limitation.
106 mirrors. 106 of the Factories Act.
Yes.
No court shall take cognizance of any offense
Yes, I know that. You show me the date
From the
line,
date of the knowledge.
date of the knowledge. You show
Yes.
me the date line.
If your lordship will kindly see the prosecution report,
Yes. Come to page 25.
yes, I'm just giving.
Date of incident is
Your lordship will kindly see page 25.
yes. 5/11/2014
Yes.
is the date of incident.
Incident.
Okay, at 9:45 is also
Column 5.
telephone
On 5,
over telephone same day.
Yes.
Over telephone same day.
Information.
Form 18 is 7/11
So the-
7/11, my lord.
is the date to be reckoned.
Yes, that is the date to be.
7/11 and complaint filed on
11 pa kholya, kaun sa code date? No.
complaint
5/11.
filed
4/2/15, my lord.
5/11/2014 is the date on which he was intimated over telephone.
23
And he also, in the prosecution report, he also refers that date. This is the prosecution report.
Yes.
So he refers that date.
And the complaint filed on the 23rd December 14.
Yeah, is the 90th after the 90th day. And if I have filed the various judgments of the,
No, it can't be can't be, sir. Just see, it is on December,
yes,
23rd December.
no, yes.
November, this has happened.
It has to
Next
be,
month.
it has to be calculated 30 days a month. That is the settled law.
Calculate from where you are calculating? From 7/11.
No, 30th, from 5/11. 5/11, 30th. Your lordship may kindly see the judgments are given.
Suppose you will calculate from 7/11.
30 days a month. 3 months has to be 90 days.
In any case, 23rd
That is the
December
law.
is beyond.
Your lordship may
30
kindly
days.
see I have given all the judgments.
Yes.
First of all, this has been in a case under the,
Yes. Which paragraph, sir?
I am showing minutes. First judgment is that of
Made within 3 months.
yes.
The limitation is
Within
3.
3 months, that is the provision. That is the Honorable Apex Court has also said. But if your lordship will kindly say, the judgments at serial number 5 of the Jharkhand High Court, which has been already has been referred to and has been accepted by the Apex Court also.
Jharkhand.
Yes.
Yes.
At paragraph 11, a mere perusal of the above provision makes it abundantly clear that the complaint must be filed within 3 months on the date on which the commission of offence came to the knowledge of the inspector. The period of 3 months referred to under section 106 of the Act means 3 calendar months, that is 90 days, calculated at the rate of 30 days per month.
But in your case, within 1 month it is filed.
No, it is
1.5 months.
after 3 months.
No, just see the date, sir. Just see the date.
In my case, it is after 3 months.
No, you are talking about this one.
No,
Anil
no.
Kumar.
1/8.
One is not mine, one is Amar one.
1/8/2020.
Anil Kumar within 1.5 months.
Yes,
Incident happened in
yes, yes.
5/11 and complaint filed on 23rd December.
No, 23rd.
Next month.
No, not next month.
This is Anil Kumar. In which is your
No.
Anil Kumar?
It is not.
And give another one.
Complaint was filed on.
Srinivasan. Srinivas, yes. You are in Srinivas, huh? Who is appearing for Anil then?
Sir.
Then
I am appearing.
you don't have a case.
Yes. Complaint has been filed after 90 days.
Just see, sir, I'm just showing. Come
Yes,
to the page 25.
Yes.
Come to page 25.
Your Lordship.
Page 25 is the complaint.
Yes.
Finally, next page, come to 26.
Place in my brief, place
And come to page
page
28.
16. Your Lordship, kindly see page 16. In the court of Judicial Magistrate Balasore, the complaint has been filed.
16.
It has been filed
On
12/8. Sorry, Milord, it has been filed on 4/2/2015.
okay, 4/2/2015.
15.
Oh, 1 minute.
4/2/2015.
4/2/15.
5/11/2014 is the occurrence and he got the information.
7, from 7 if you calculate 7.
So the 30 days is to be calculated for the each month.
February.
So that is the, I have given also along with that some apex.
You say that knowledge is from
5/11.
5/11,
Yeah,
not
he-
the
He
7/11.
himself gives date and time and place of occurrence, first information report, if any, over telephone on 5/11. He himself writes in the.
What is the sanctity of Form 18 under
Yes.
Rule 97?
Yes.
Form 18.
Yes.
Form 18 was
It is
received
the,
on 7/11/2020.
no, we intimated according to the complainant. He got the information on 5/11.
Yes, sir.
My lord, what happened is, my lord? My lord, page 16, column number 4, my lord.
Yeah.
First information report, if any, over phone on 5/11/24, 14, 5/11/14, followed by report of accident in form number 18, received on 7/11/2014, my lord.
Yes.
My lord, so, my lord, I got the instruction from the, my lord, the additional director of factories, my lord. He stated that limitation received, intimation received to this office by management on 7/11/2014, my lord.
By Form 18.
My lord,
Form 18.
my lord, form 18, my lord.
But your.
On 7/11/24,
But the language employed in
My
this
lord.
provision is
my lord.
date of knowledge.
My lord.
Knowledge, you got the knowledge the day when you received it.
But form number 18, my lord.
Knowledge to the inspector, not to the office.
My lord, if it is, my lord, calculated 7/11/14, my lord, then prosecution launched on, my lord, 4/2/2015.
That's right.
Within, my lord, 90 days, my lord.
No.
But you show me some
Madam.
judgment that Form 18 assumes importance.
My lord,
Once the knowledge comes on the same day,
my lord,
over telephone it was intimated to you,
my lord.
then how can you say that you will
But,
be waiting till 2 days?
But they launched the prosecution, my lord, on 4/2/2015, and they, my lord, the form number 18 received on since 7/11.
I understand it.
That is,
You
my lord.
show me some judgment.
That
Which
is
will
what
be the date to be
Madam.
reckoned with?
My lord.
It is from the date when the Form 18 was filed or the knowledge
That is
over phone.
Your Lordship-
Because the language employed in 106 is the knowledge.
Your Lordship, give me 1 minute time.
Yes.
I have cited that the decision and section 106 limitation says, no court shall take cognizance of any offence punishable under this act unless the complaint thereof is made within 3 months of the date on which the alleged commission of offence came to the knowledge of the inspector.
So it is
So knowledge has
inspector.
come on
Over phone तो
5/11.
inspector को बोला गया है.
He himself said, I got the information on 5/11.
My lord, to that respect, my lord, I want some time, my lord, as because, my lord, if, my lord,
I have reserved the judgment. You
my
have
lord,
to tell me.
if the my lord, 5/11
and-
taken into consideration, then no, I have no question, my
And
lord.
my lord,
If 7/11
That is what
taken
his
into consideration,
case is.
my lord, my lord,
He has intimated over phone,
my lord.
admittedly.
He himself-
And you, it is
that is
your
the case,
complaint. It is your complaint. It is not their complaint.
My lord,
You
nine-
say.
my lord, from where, my lord, the 90 days will be calculated, my lord, when
From the
form
date
is
of-
received or telephone.
from the date of the knowledge.
But the language says
My lord,
date
date
of
of the
knowledge.
knowledge.
Inspector.
My lord,
Date of the knowledge.
Inspector.
my lord.
And
You have a difficult case. It seems.
And my lords, I have
Anyone?
given my some judgments in which my
Yes, I
case,
got it.
they have all
30 days.
30 days.
That
So
I-
in that view of the matter, it is beyond 90 days.
30. 40?
Yes.
Yes. Yes,
आपने
madam.
खुद भी तो मुझसे डैश मारना जो उनसे आरोप कैसे है
Yes.
Yes.
Yes, it is 25. It is 25 6.
Date of incident is 25th. So telephonic information is received on 25th itself. And the form 18 is received on 27th, that is 2 days after.
Yes.
And the
Filed on?
17th.
410.
And my case is a bit different from my learned senior because you know I am neither the manager neither the occupier.
That's right. That I noted. On merits you say. But on the ground of limitation, it is everything will be same. Sir also there at the same.
I have given all the judgments. I have given 4 or 5 judgments.
Yes.
These
And now
judgments-
the ball rests in your court.
Well,
Otherwise, I'll allow.
well,
Okay. And please see
Madam,
Form 18.
one-
What is
one-
the sanctity of Form 18?
Madam.
Because the language says that
Madam.
knowledge
knowledge.
to the inspector,
Yes.
not to the office.
Yeah, he himself in the form writes, I got the information on 511 hotel.
That's the whole difficulty. Yes. I'll take care of it.
Item 2.
My lord, the offense under section 307 and other offense.
Yes.
In previous occasion, my lord, they verify that the injury to the informant, whether that is simple or grievous. I got the charge sheet copy. That's good.
Yeah, so I didn't follow you.
But they have came here by for compromise informant and the accused, my lord, sole accused, my lord.
So like it, my lord.
Okay. 307.
My lord, my lord. That injury,
Okay, injured. Just show me the
that is simple in nature.
simple.
My lord,
Which part?
my lord, the left elbow.
Yes, Mr. Raghunath.
That is there.
Right up. At the instance of opposite party number 2, FIR number so came to be registered against the petitioner and petitioner. The investigation is over.
My lord, investigation open.
Cognizance.
I challenge the order of cognizance, my lord.
Charge sheet has been filed in this case, and cognizance of the offences has been taken by the court below. At this stage, the parties stated to have settled the dispute and filed the present petition for quashing of the entire criminal prosecution initiated against the petitioner at the instance of opposite party number 2. Petitioner and opposite party number 2 are present in the court, being represented by their respective lawyers. They have also filed their self-attested copies of Aadhaar card to establish their identity, which are taken on record. Now, where is the affidavit?
Affidavit filed, my lord.
The parties have also filed a joint affidavit dated 6/9/2024 inter alia stating as under para 2 and 3. Para 2 and 3. The counsel for the petitioner hands up the medical the injury report of the opposite party number 2 conducted on 2/8/2023. The injury report indicates that the injury sustained by the opposite party number 2 are simple in nature. Simple in nature. Mr. Raghunath, Council of the State submits that since the parties have settled their dispute and the medical report
My lord, the
reveals
Dr. Mansan Barik, my lord, opinion, my lord, sought for, my lord, by the IO, he stated that perusal of the injury report found that nature of injury is simple.
submits that he has obtained instruction from IIC.
No, my lord, the charge sheet, my lord,
Charge sheet.
IIC
Charge sheet.
mentioned. In the charge sheet, IIC mentioned.
Reveals that the injury sustained by the injured in the present case are simple in nature. There is no legal impediment in exercising the jurisdiction of this court under section 482 CMC. Regard being head to the aforementioned circumstances and in view of the judgment of futile exercise, therefore, the petition deserves merit. Accordingly, the so and so request subject to the petitioner paying how much will be to the informant?
My lord,
Subject to the petitioner paying 2,000 to the informant.
My lord,
Opposite party number
1,000.
2,000.
1,000.
1,000 to the 1,000 and 1,000 to the bar. Because you are wasting court time. 1,000 to the opposite party number 2 injured and 1,000 to the High Court Bar Association. You will let him pay. What is he doing, by the way?
Petitioner. Dohivara business in front of ABID college. Aini Seva Bhavan and OPID court.
बार को 500 कर दिया.
500.
Okay,
But item 3, I'm seeking for an adjournment to the first week of October. But we have sought for certain documents from the court below, Your Lordship.
On the request, adjourn. Huh?
But first week of October, may I request Your Lordship?
Second week. First week, second week.
Grateful, Your Lordship.
May I please? The petitioner has filed this.
Yes, sir.
LMC challenging the order dated 28/11/2023 passed by the JMFC under annexure.
Yes, yes. Tell me, what is this?
Petitioner is a advocate as well as a notary public in the local bar.
What are the allegations?
Your Lordship may kindly see.
That makes the case worse. If the lawyer does anything wrong.
No prima facie.
No immunity for a lawyer.
No.
Legal immunity.
My lord, your Lordship may kindly see the running page 11 of the brief.
Here.
The informant alleges that in the year 2013, a power of attorney was executed by one Pradyumna Kesari Mahapatra.
Yes.
Before the notary public, middle part of the.
You are the notary public.
I am the notary public. And on subsequently, the informant.
Power of attorney for what?
For withdrawal of some money.
How come? What is the money amount?
Money. There was a civil dispute. A land was acquired by the government for expansion of the road, and accordingly.
You are the notary public.
I am the notary public. It is alleged that.
See, the problem is the notary public are started doing marriage, divorce.
No.
And sale deed and everything they do.
No.
That's the whole difficulty.
Your Lordship may kindly see running page 11.
Yes.
ଉକ୍ତ ମୋକଦ୍ଦମାରେ 1 ନମ୍ବର ପକ୍ଷ ତଥା ଅଦ୍ୟ ରୁଜୁ ହୋଇଥିବା କେସ୍ ନମ୍ବର 1 ନମ୍ବର ମୁଦାଲା ପ୍ରଦ୍ୟୁମ୍ନ କେଶରୀ ମହାପାତ୍ର ଏକ ନକଲି ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ଭାଇଡ୍ ସିରିୟଲ ନମ୍ବର ଟୁ ସଂଗ୍ରାମ କେଶରୀ ବିଶ୍ୱାଳ ନୋଟାରୀ ପବ୍ଲିକ. ଆଇ ଆମ୍ ଦ ନୋଟାରୀ ପବ୍ଲିକ ସଂଗ୍ରାମ କେଶରୀ ବିଶ୍ୱାଳ କୁ ନକଲି ମୁଦେଇଙ୍କ ଠାରେ ଆମ୍ଭେ ମୁଦେଇଙ୍କର ବିଧବା ମାଙ୍କର ଦସ୍ତଖତକୁ ନକଲି କରି ଉକ୍ତ ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣିକୁ ପଞ୍ଜୀକରଣ କରାଇବା ସହ ମାନ୍ୟବର ଅଦାଲତ ଡିଷ୍ଟ୍ରିକ୍ଟ ଆଣ୍ଡ ସେସନ ଜଜ୍ ବାଲେଶ୍ୱରଙ୍କ ଅଦାଲତରେ ଚାଲୁଥିବା ମୋକଦ୍ଦମା ଏକ୍ଜିକ୍ୟୁସନ ମିସକେସ୍ ନମ୍ବର.
Is that not enough?
My lord, I am not executed. I was only.
You have attested.
I have only.
Don't you have any responsibility? Who has signed it in front of you?
Your Lordship.
Have to sign.
Your Lordship may kindly see.
Impersonated. Complete case of impersonated.
No, my lord. The Pradyumna Kesari Mahapatra has executed.
What was your job?
My lord.
What was your job?
I am a notary.
Notary. What was your job? If somebody signs, it will not be. They will not sign in your presence. And where is the register? Have they signed in your register?
They have signed the.
Who has signed?
My lord, your Lordship.
Have you checked the Aadhaar card?
In the year
have you identified?
In the year 2013,
that is your responsibility. You have not done.
Your Lordship may kindly see the rest part. Yes. Subsequently, the informant demanded the.
I am not inclined.
Your Lordship may kindly see, as per section 13 of
lose your notary public.
Your Lordship may kindly see, as per the Act of the Notary Public, no court shall take cognizance without the prior sanction. Your Lordship may kindly see.
You raised all these points there.
My lord, that. My lord, the complainant has only alleged that he was demanded the document, copy of the document. But when I did not provide the same, he lodged the complaint petition against me. That is the whole crux of the case.
It's a 200 complaint and 202 inquiry.
And in the 202 inquiry, he was not stated the name of the petitioner at all. Your Lordship may kindly see the 202 inquiry. Your Lordship. I am just now giving.
Go to this. Just now, everything just now.
That was not available at the relevant point of time.
You don't have a case, unnecessary, don't try.
Your Lordship may kindly see.
You either withdraw, I'll write something, then it will be problematic for you. Better you withdraw with the liberty to raise all these points at the relevant stage. Right on. Land counsel for the petitioner seeks to withdraw the present petition to raise all the points at the appropriate stage before the trial court. With this liberty, the petition is disposed.
Obliged.
File. Yes. Maybe. You file a discharge petition, whatever. Yes.
Maybe.
Yes, sir.
Rejection of my 205 petition.
Who are you?
It is a case under section 130 to the NI.
Who are you?
I am the accused.
Accused, okay. Yes.
My lord.
I'll
Yes.
issue notice. Let us see. Issue notice. No stay, huh? Issue notice.
And
What is the check amount?
2,70,000.
Why don't you pay?
Say, COVID.
Give him the check. Oh, whatever. You ask him, give installment and finish it up.
Hey, you compromise.
I'll issue notice and refer it to mediation.
NBW for that time.
NBW to
to
execution of NBW stay till next date of meeting. Okay. NBW, what is the date? NBW?
My lord. NBW for that.
Not there.
Hey, 9/8/2020.
NBW Land Council for the petition submit that NBW has been issued against the petitioner. Petition issue notice to opposite party. Written opposite party number 2 written within a week. In the meantime, execution of NBW issued on dated zone also is stayed till next date of meeting. It is made clear that if necessary steps are not taken to ensure the service of the opposite party number 2, the interim order granted today shall automatically stands vacated. Yes, otherwise you will not file the.
No, that is not by purpose.
You bring him, I'll send to mediation and come with 1 lakh rupees.
Yes, my.
You come with 1 lakh rupees,
Yes.
I'll persuade them. And the remaining amount with 2 installment or something. Come with 1 lakh rupees.
Yes.
Put it on immediately after 1 week. That is the 8th
After vacation.
9th.
After vacation also.
Yes, 9th or 10th.
Vacation पर आसू 1 लाख मते ये arrange कर जाती है.
Okay. Then let it be on 21st.
Yes, sir.
21st, 22nd.
22nd.
Okay. You arrange 1 lakh rupees.
Yes,
sir.
Item 6.
May I please?
Vigilance Council will ask for time. Passover, madam.
Today,
So that's not there.
Yes. What is this matter?
The release of laptop matter, my lord. So
Oh,
remember,
laptop. Wait, he may come. Pass over. Oh, that boy, his father is accused and
yes,
his
father
boy-
is an accused, but
official laptop
yes,
is taken. Okay. 110?
Mr. Das also, the telephone him, he is coming. That business matter, my lord, the release of cash security.
Let him come.
Let him come.
Yes, yes. Let it be taken up at 12 o'clock. Let Mr. Das will come by that time. You can do your other work. Yes. Yes.
Item 7. 7 ballot.
Which party number 2, sir?
But the victim also appearing through his madam.
Yes.
Earlier, my lord, victim already appeared, my lord.
Yes.
My lord. But the council.
What to do? What to do? Pass over. Some dismiss कर देते.
Item 9.
If you are there, you argue, don't ask. Today 90 matters are there. How can I pass? Yes.
3 bail applications there before your lordship, my
Yes.
lord. It is about a case of NDPS, 154 kilo 400 gram of
Yes. Custody since
ganja, my lord.
custody.
Custody since all the petitioner are arrested on 19/5/2022, 23, sorry.
Okay.
And
What did this say?
What happened in this case, my lord?
Yeah.
There are 4 accused persons carrying ganja in a Scorpio vehicle, my lord. Out of them, my lord, one petitioner, my lord, Vikram
Yes.
Sonani,
my lord. His, my lord, bail application 752 on dated 5/8/2024, your lordship, they, my lord, liberty to revive the bail application before the court below.
Why don't you?
beg pardon, your lordship.
All of them are
Beg
similar.
pardon. Because the petitioner have criminal antecedent. Because that petitioner have criminal antecedent, for that reason your lordship directed. But in this case, my lord, all the 3 petitioners are first offender.
How much?
154 400.
Cross the 100.
But my
Call
lord,
for a call for report from the stage of trial. Let us
and also the criminal antecedent of all the petitioners.
call for a report from the stage of trial and antecedent of
So far my client is concerned, he's a local person, 18 or boy, my lord.
Let us see what is the stage. 18 years doesn't mean that you have immunity. Yes, I'll call for the report. I'll see because the Ravi Prakash judgment we can think of.
Well,
Just see Ravi Prakash
great.
after 3 weeks. Yes.
Grateful.
Item 10.
So on behalf of Florida Matters,
Yes, sir.
on behalf of Florida Matters, the petitioner has been charged for the alleged commission of the 457, 380, 436, 435,
Yes.
294, 506 of IPC matters. That was the 3 and 4 of PDP Act matters.
Yes.
The petitioner is custody since matters 2/1 2024 matters.
24.
Matters.
Okay.
January matters. 8 months matters, 20 days matters.
Yes.
The infant was present in the court premises matters. The present
Your lordship permission, madam. Item 7, victim and I was present, madam. The counsel from the virtual one, madam.
Barampur. Okay. I'll take it.
So that
I'll take it up. 1 minute, sir.
Yes, sir.
There are some. Yes. Items.
7.
Yes, item 7. What has he done?
Madam, they committed, my lord. I've got the charge sheet, my lord.
You have CD with you?
My lord.
You have CD with
CD, my lord.
Yes.
My lord.
Tell
CD
me
also
the-
charge sheet sometime, my lord.
Yes.
CCTV not verification, my lord. 10 data. Lord, I did out one statement, my lord. One statement, my lord. Nihir Kumar Das, the petitioner. ପ୍ରବଳ ମଦ୍ୟପାନ କରି ଆମ କୋର୍ଟ ମାନେ କେନ୍ଦ୍ରାପଡ଼ା କୋର୍ଟ ଇସ୍ୟୁ ମାଇଲଡ that already received once ମାଇଲଡ କୋର୍ଟ
You are the pescar.
No, I'm the sweeper matters.
Sweeper, okay.
ଆମ କୋର୍ଟ କର୍ମଚାରୀ ପରିଷ୍କାର ବାବୁ ସେ ଦୁର୍ଯ୍ୟୋଧନ ନାୟକକୁ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳିଗୁଜ କରି ଦି ପିଟିସନର ଗାଳିଗୁଜ ସହିତ କହିଲା କି ମୁଁ କଣ କରୁଛି ଦେଖେ ମୁଁ ପ୍ରମାଣ ରଖିବି ନାହିଁ। ଏହାପରେ ଆସାମୀ ରାଗିକି ପଳାଇଗଲା। ମୁଁ ପ୍ରାୟ ରାତି 9ଟା ଘଣ୍ଟା ବେଳେ ପେସ୍କାର ବାବୁଙ୍କ ଘରକୁ ଖାଇବାକୁ ଯାଇଥିଲି। ଖାଇସାରି କୋର୍ଟକୁ ଆସି ଦେଖେ ତ କୋର୍ଟ ଝରକାପଟୁ ନିଆଁ ଓ ଧୂଆଁ ବାହାରୁଛି। ମୁଖ୍ୟ କବାଟ ଭିତର ପଟୁ ଆସାମୀ ବନ୍ଦ କରି ଦେଇଥିବାରୁ ମୁଁ କୋର୍ଟରୁ କବାଟ ଭାଙ୍ଗି ଦେଖେ ତ କିଛି ରେକର୍ଡ ଏକାଠି କରି ନିଆଁ ଲଗେଇ ଦେଇଛି। ମୁଁ ତୁରନ୍ତ ପେସ୍କାର ବାବୁଙ୍କୁ ଫୋନ କରି ଡାକିଲି। ସେ ଆସି ପହଞ୍ଚିଲେ। ଆମ ଦୁଇ ଜଣଙ୍କୁ ତୁରନ୍ତ ନିଆଁକୁ ଆୟତ୍ତ କରିବାକୁ ଚେଷ୍ଟା କଲୁ। କାଳେ ଆସାମୀ ଲୁଚିଥିବ ଖୋଜାଖୋଜି କଲୁ। ଆସାମୀ ଆମକୁ ଦେଖି ଛାତ ଉପରୁ ଡେଇଁ ପଳାଇଲା ବେଳେ ଆମେ ଦୁଇ ଜଣ ଦୌଡ଼ି ତାକୁ ଧରିବାକୁ ଚେଷ୍ଟା କରିଥିଲୁ କିନ୍ତୁ ଧରି ପାରିନଥିଲୁ। ତାକୁ ଦେଖି ଜାଣିବାକୁ ପାଇଲୁ ଯେ ସେ ଆମ ସୁଇପର ମିହିର କୁମାର ଦାସ ଅଟେ।
Renew the bill. You have destroyed the court record. So dangerous. Right, petitioner is agreed by the order dated.
Custody since 8 months.
Whatever. You are dangerous. The court record you are burning inside the court. I don't know. Agreed by the order dated 19/1/2020, whereby his bail plea has been rejected. The allegation against the petitioner is, I don't know, so and so. I have perused the statement of the witnesses recorded under section 151 CRPC by the police. It reveals from the statement that the petitioner, who is a sweeper employed in the court, is instrumental in burning the records of the court. He was trying to escape by jumping from the roof up to the house, and at that point in time, the witnesses have apprehended him. Regarding to the nature of acquisition and the fact that there are witness to the occurrence, I am not inclined to enlarge the petitioner on bail. However, liberty is granted to the petitioner to renew the bail plea after the recording of the statement of recording of the evidence of the materials. Yes.
Item 11.
Yes.
My lord, kindly pass over.
Pass over today may not be possible. CD call for CD. Okay. Yes. Yes, 12. Yes. Custody.
Yes, the petitioner in custody since about last 1 year.
Date.
That is on 10/10/2023.
10/10/23.
2023.
Okay.
Yes. In the meantime, charge sheet has been filed on 30th December 2023.
30th December.
Yes.
Okay.
So far as the present petition is concerned,
Yes.
the charge sheet has been filed under section
Yes.
Section 364,
201, 302, 120B. Read with
So what are the allegations against him?
allegation he was because there are two spots. Initially, this person detained the deceased along with some other persons. Only overduct is that he has detained the person, then he was taken away to another place, and 2 days after dead body has been found, and one witness who is claiming to one witness over WhatsApp video call.
Yes.
He has stated, he has not taken this person's name, but what he has stated that the other persons, the co-accused persons, have restrained him on the way. I am reading that video call. That is the only evidence. Then, of course, 2 other witnesses are claiming to be eyewitnesses. That is Sambhu Khunti. I am reading this.
Read the eyewitness.
My lord, they were implicated on the basis of CCTV footage when they were kidnapped or deceased. And the PM report is, my lord, that is home race arising out of some injuries. And leading to discovery, so 3 numbers of sword, iron rod, spade, gun, it was seized from the accused persons. And my lord, I am reading 2 statements of the witnesses. Who was with the deceased at the time of occurrence. He is known as Satya Patra, my lord.
Satya Patra.
Satya, my lord.
Yes.
Yes. जे এই কেসরে ମୁଁ ଉପସ୍ଥିତ ହୋଇ କୋଦଳା କୋର୍ଟକୁ ଆସିଥିଲା ଦିନ 12:45 ଗୋଟେ ମଧ୍ୟରେ ନିଜ ଗ୍ରାମକୁ ଫେରିବା ବାଟରେ କୋଦଳା 7 ନଳ ଛକ ନିକଟରୁ କୋଦଳା ଥାନା ଅନ୍ତର୍ଗତ ଜଗନ୍ନାଥପୁର ସନିଆ ସେଠୀ, ହୀନ ସେଠୀ, ସଙ୍ଗୀ ସେଠୀ, ପରିଡ଼ା, ଚନ୍ଦନ ସେଠୀ, ଚନ୍ଦନ ରାଉତ, ଲିପୁ ନାହକ, ବାବୁ ଓରେସ ଆଲାଇଜ ରାକେଶ ପରିଡ଼ା, ଆଲୋକ ପ୍ରଧାନ, ସଞ୍ଜୟ ରାଉତ ଲିଟୁ ନାୟକ and others ସେମାନେ ଦୀପୁକୁ ଅଟକାଇ ତାର ମୋବାଇଲ ବନ୍ଦ କରିଦେଲେ। ଦୀପୁ ଇଜ ଦ ଡିସିଜ୍ ଏବଂ ମୋର କଲର ଧରି ମତେ ବାଡେଇବାରୁ ମୁଁ ପ୍ରାଣ ବିକଳରେ ସେଠାରୁ ପଳାଇବାକୁ ସକ୍ଷମ ହେଲି। ସମସ୍ତେ ବାଇକ ଯୋଗେ 7 ନଳ ପଡିଆ ପାଖକୁ ନେଇଗଲେ। ଚନ୍ଦନ ରାଉତର ସ୍କୁଟି ଯୋଗେ ଦୀପୁ ପାତ୍ରକୁ ସନ୍ୟା ସେଠୀ ଓ ଚନ୍ଦନ ସେଠୀ ତାକୁ ମଝିରେ ବସାଇଲେ। 7 ନଳ ଖେଳ ପଡିଆକୁ ନେଇଗଲେ। ତାପରେ ମୁଁ ପ୍ରାଣ ବିକଳରେ ମୁଁ ମୋ ଘରକୁ ଫେରି ଆସିଲି। ତାପରେ ଘର ଲୋକଙ୍କୁ ଜଣାଇଲି ମୁଁ ଆଜି ନିଶ୍ଚିତ ମୋ ସାଙ୍ଗ ଦୀପୁକୁ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଅପହରଣ କରି ନେଇଛନ୍ତି। Though they were kidnapped,
Kidnappers, he has witnessed the kidnapping part.
Kidnapping, my lord.
Yes.
Another reminder who has seen the photograph of assault.
Who is that?
In is the friend's mobile.
Yes.
His name is, my lord, Rudra Patra, my lord. Rudra, my lord.
Yes.
He stated जे मो भाई दीपू कोदला एडीजे कोर्ट रे केस रे उपस्थित थिबारु कोदला कोर्ट को आसीथिला दिन 12:45 गोटे मध्यरे निज ग्राम को फेरिबा बाटरे कोदला 7 नळ छक निकटरू कोदला थाना अंतर्गत जगन्नाथपुर छाचिनार संग्राम परिया पिता सुवांशो बलराम सेठी सन्या लिटू नाहक संजय राउत प्रेजेंट पिटिशन दीपू पात्र को अपहरण करी नै 7 नळ खेल पड़िया पाखरे प्रबल मार मारी थिबार फोटो मो भाई दीपू पात्र जने सांगक जरिया मोबाइल माध्यम देखिली सूरत रही सेठी भाई दीपू पात्र माड़ मारी दिन संगे संगे संग्राम परिवार गैंग उपरोक्त आशा माने मो भाई दीपू पत्र को योजनाबद्ध भाव अपहरण करी मारछन। सो दीज आर द सफिशिएंट एविडेंस
The statement of Satya Patra has been recorded on 8/10/2023.
Yes.
8/10. FR has been lodged on 6/10/2023 by the father of the deceased
After 2 days.
against unknown persons.
The father might not be knowing it, therefore unknown only. Yes.
And the Rudra Patra, his statement also has been recorded on dated 8/10/2023. 2 days after. 2 days after. That is important loss. And the person who is claiming to have seen the video over WhatsApp, that means accumulate banila wale tar WhatsApp video ta dekhile. Is a digital eyewitness loss. What he has stated,
You can say that digital eyewitness, I can say that is a visual
no,
visual evidence.
visual through digital mode.
Visual evidence.
Digital mode.
Yes.
Your loss is correct. Plus that was I am reading that statement.
I think you should try after these witnesses are examined.
Because I'm this person, what is the role of this person? It is subject to lordship's appreciation. I am with the lordship's discretionary zone. No, subject to lordship's appreciation. What is his role? His role is he has detained only. And subsequently, because he was taken, because as my learned friend has rightly
Kidnapping part is there.
detained, he has detained, only detained.
It is seen. It is seen.
Yeah.
Thereafter, you were beating, visual evidence is there.
No, that is not there. That is absent. That is absent.
Rudra
Shambhu
Patra.
Khuntia, I am reading. Shambhu Khuntia. ଗତ 6/10/2023 ତାରିଖରେ ପ୍ରାୟ ଦିନ 2 ଘଣ୍ଟା ସମୟରେ ମୋତେ ଗୋଟେ ହ୍ୱାଟ୍ସଆପ୍ ନମ୍ବରରୁ ଗୋଟେ ଭିଡିଓ କଲ୍ ଆସିଲା, ଯାହାର ନମ୍ବର 8511026669 ଓ ମୁଁ କଲ୍ଟି ଉଠାଇ ଦେଖିବାକୁ ପାଇଲି ଯେ ଆସାମୀ ମାନେ ମୋତେ କହିଲେ ଯେ ଦେଖରେ some slang language has been used, ତମ ପିଲା ଦୀପପତ୍ରକୁ ଆମେ ସମସ୍ତେ ମିଶି ମାଡ଼ ମାରୁଛୁ କହି ଗୋଟେ ବାଉଁଶ ଠେଙ୍ଗାରେ ମୋ ସାଙ୍ଗ ଦୀପପତ୍ରକୁ ବାଡେଇଲେ, ଲାତ ଗୋଇଠା ମାରିଲେ ଓ କହିଲେ ଆଉ ତମେ 2 ଜଣ ରହିଲ, ତୁ ଓ ତୋ ଭାଇ ତମେ ଯଦି ଗାଁକୁ ଆସିବ ତମକୁ ମଧ୍ୟ ଜୀବନରେ ମାରିଦେବ ବୋଲି କହିଲେ। ସେହି ସମୟରେ ମୋ ସାଙ୍ଗ ଦୀପପତ୍ର ମରିଗଲି ଚିତ୍କାର କରୁଥିଲା। ହ୍ୱାଟ୍ସଆପ୍ ଭିଡିଓ କଲ୍ ସମୟରେ ଯେ ଛଚିନା ଗାଁର ହୀନ ସେଠୀ, ଚନ୍ଦନ ସେଠୀ, ଚନ୍ଦନ ରାଉତ, ଲିପୁ ନାହାକ, ରାକେଶ ପରିଡ଼ା, ଟୁବା ଆଲିଆସ ସୌଭାଗ୍ୟ ପରିଡ଼ା, ବିକୁ ଆଲିଆସ ବିକ୍ରମ ପରିଡ଼ା, ସଙ୍ଗୀ ଆଲିଆସ ସଂଗ୍ରାମ ପରିଡ଼ା, ଉତ୍ତମ ବିଶ୍ୱାଳ, ବାବୁଲୁ ଗୌଡ଼ ଓ ଅନ୍ୟମାନେ। My name has not been taken. Visually ମୋ ନାଁ ନାହିଁ।
One witness might not have taken.
No, this is as your lordship has said, it's a visual because over video, over a WhatsApp call video, because these are all planted witnesses plus. Because in this process, many persons can be made accused in this case. What this person has statement has been recorded on 1410.
Anyway, you repeat your bill. Right, and
I am appearing for the informant here.
रोहन आज्ञा हमको कभी भी इन्फॉर्मेटर कौन क्वेश्चन दे
other accused persons bail your lordship have already rejected, and so far the petitioner circumstance of the present case is concerned, one witness who had come to depose and on his way return he was kidnapped and succumbed to injuries.
Anyway, since I am not inclined to grant bail, why should I hear you? Yes.
Grateful, your lordship.
What my learned friend is stating, that is one Bablu alias Rakesh Naik, they are the pre-charge sheet stage रे आस्तिला, ସେଥିପାଇଁ ଆପଣ ତ charge sheet ପରେ ଆସିବା ପାଇଁ ସେଟା କହିଥିଲେ। And
now you repeat your bail plea after these witnesses are.
No.
Why I will not keep pending.
Also I don't want that your lordship should keep it pending.
And rather you repeat your renew your bail plea after these witnesses are examined. I will direct the trial court to expedite recording of the right.
For a moment,
may I dated 22/1/2024, whereby bail plea has been rejected. The statement of the witnesses to the occurrence, alleged occurrence, were recorded by the police under section 161 CRPC, which was read over extensively at the bar. Two witnesses, namely Satya Patra and Rudra Patra, are stated to be the eyewitness to the occurrence. Occurrence relating to the kidnap as well as.
No, I beg your pardon. Not kidnap. Only restrained, because kidnapped by 2 persons.
Okay, right on. Only stated to be the eyewitness to the occurrence. Regarding head to the nature of evidence collected by the police, which are part of the charge sheet, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea before the trial court after the examination of the so-called eyewitnesses. Trial court is directed to do well to see that the material witnesses, public eyewitnesses, shall be evidence of eyewitnesses and material witnesses shall be recorded preferentially over all other witnesses. If for any reason the evidence of the material witnesses cannot be recorded within 6 months, the petitioner may renew the bail plea after the expiry of 6 months. With this liberty, the petitioner is disposed of. Yes, next.
May I please, my lord? Here the accused petitioner is in custody since 22 November 2023 on an allegation on section.
Yes. What are the allegations?
Well, this is an allegation of child marriage, and there is also section 6 and 17 of the POCSO Act, read with section 376(3).
मुत्ते 14 वर्ष
Age of the petitioner being 20 years. Yes.
मुत्ते 14 वर्ष होइतला बेले मो माँ भौणी मो इच्छा विरुद्ध रे 22/2/21 दिन ରିଙ୍କୁ ପାତ୍ର ସହ ମୋର ବାହାଘର କରାଇଦେଲେ। ବାହାଘର ପରେ ମୋ ସ୍ୱାମୀ ମତେ ପିଲା ଜନ୍ମ କରିବାକୁ କହିଲେ, ହେଲେ ନିଜର ବୟସ ହୋଇନଥିବାରୁ ମୁଁ ମନା କରିବାରୁ ମୋର ସ୍ୱାମୀ, ଶାଶୁ, ଶ୍ୱଶୁର ମତେ ମାରପିଟ କଲେ। ମୋ ମା ଓ ମାଉସୀର ଏକଥା ଜଣେଇବାରୁ ଏମାନେ ମଧ୍ୟ ମୋ କଥା ଶୁଣିଲେ ନାହିଁ। ବାଧ୍ୟ ହୋଇ ମୁଁ ଥାନାରେ ଅଭିଯୋଗ କଲି।
There is no allegation.
14 ବର୍ଷରେ forcibly gave marriage her.
Who gave the marriage?
The mother and
Parents?
yes.
And in truth, handicap.
Yes, madam.
Forcibly marriage to him, and also equally that this person also tortured her.
No, there is
And
no allegation. There is no sexual allegations.
Compelled to produce the
against
child.
And what is the medical evidence?
Nothing, my lord.
Nothing.
Medical evidence. Where have you said that you are handicapped?
No, it is in the statement. It is in the statement as well as
What kind of handicap do you have? Do you have medical?
ମୋ ବିବାହ ଅଟ୍ୟ ଗୋଟେ ଛୋଟା ଲୋକ ସହିତ ଠିକ କରିଥିଲେ. This is the statement of the victim. I have the medical.
Read it out.
My lord.
Why are you waiting?
There are no sign of suggestive of forcible sexual assault.
Right. Petitioner is accused in the 5 number 2. The statement of the victim girl, we stated, what is the age of the girl?
14 years.
14 years was recorded by the police under section 164 CRP. In her 164, she in her statement stated that her parents have forcibly got her married. Handicap. And after the marriage, the petitioner forced him to have physical relationship and carry physical relationship. When and also torture. When this matter was informed by her to her mother and Mausi, inverted comma Mausi, they have also not paid any heed to it. Accordingly, the case has been registered. Petitioner is in custody since 27/10/2023. It is the counsel of the petitioner submits that the petitioner is in handicap, and he is in fact he indeed is also a victim of the circumstances. Since he is a handicapped person, he was forcibly asked to marry the minor girl, and eventually he became an accused. Regarding to the nature of allegation against the petitioner and period of custody, I'm inclined to enlarge the petitioner on bail accordingly. Yes. Next. Madam Ji, as today's Passover is difficult, you argue what is this matter?
My lord, it is 376.
Yes. I'm putting it after 2 weeks. Please file the relevant documents. You have not filed anything, FIR and all. Please file it. Only rejection order you have filed it. Okay. File it after 2 weeks.
May I please, my lord? I am appearing for opposite party number 2, my lord.
Opposite party number 2, so and so entered appearance, files Vokalatnama. Then counsel for the petition seeks an adjournment to file the additional document in the present case. Please the matter after 2 weeks. Yes.
Lord, Mr. Das name may be deleted.
Where in this case, Mr. Das name, Mr. Sarada Prasad Das.
Arthasarith Das. Arthasarith Das.
Parthasarith Das. Who is that? Parthasarith Das name may be deleted. Yes.
Okay.
16.
Petitioner is in custody since 1/12/2023, my lord.
1/12/23.
My lord, offense under section 302 and 201 and other offences, my lord.
Yes.
Petitioner implicated on basis of the co-accused statement, my lord. Only allegation against the present petitioner, she was standing at the time of occurrence.
You made the case so easy.
My lord,
Yes.
my lord, I'm sorry, my lord. This is 302 case, my lord. CD has not.
A CD. Call for the CD. Yes.
My lord, twice.
After 2 weeks, huh? 17.
Custody since 19/10/23.
19/10/23.
My lord.
Yes, sir.
And 376 is there. And 3 SCST is there.
Yes.
My lord, the victim herself lodged the FIR.
Hmm.
FIR does not disclose any kind of forcible income.
What is the age of the girl?
17.
17.
Yes.
Yes, 17.
Yes.
FIR does not disclose any kind of.
No, what is 164?
164 is there. I have filed, my lord. Page 36.
Read it out.
ମୁଁ ଜୁନାଗଡ଼ରେ ପଢୁଥିଲି ସୁମନ୍ତ ପୂଜାରୀ ମତେ ସବୁବେଳେ ଫଲୋ କରୁଥିଲା ଯୋଉଠି ମତେ ଦେଖେ ସିଏ କହେ କି ସେ ମତେ ଭଲ ପାଉଛି ସେ ମତେ ବ୍ଲାକମେଲ କରୁଥିଲା ସେ ମତେ ମାରିଦେବି ବୋଲି ଧମକ ମଧ୍ୟ ଦେଇଥିଲା ମୁଁ ଡରି ନାହିଁ ମୋର ଘର ଲୋକଙ୍କୁ କହିଲି ଡରି ନାହିଁ ମୋର ଘର ଲୋକଙ୍କୁ କହିଲି ମୋର ଘର ଲୋକ ମୋର
164.
You read one page 36.
Yes,
yes, read it. ମୋ ଘର ଲୋକ
ମୋର ଘର ଲୋକ ମୋର ପାଠ ପଢା ବନ୍ଦ କରିଦେଲେ
ଆଉ ମତେ ଗାଁକୁ ପଠେଇଦେଲେ ସେ ମୋ ଗାଁକୁ ମଧ୍ୟ ଆସିଲା ସେଠାରେ ମଧ୍ୟ ସେ ମତେ ବ୍ଲାକମେଲ କଲା କହିଲା ମତେ ମାରିଦେବ ରେପ୍ କରିଦେବ ଅକ୍ଟୋବର 7 ତାରିଖ ଦିନ ମୁଁ ଘରେ
For IPC read with 4 of DP Act LRC.
302.
No, my lord.
Yes.
FIR 302 was there, but in
Custody.
charge sheet 306 has been added.
306.
Relating
Yes.
302.
Viscera report was added, my lord, and viscera report has been proved that the poisonous compound was detected. But as for the complainant, 161 statement and the neighbor statement, that the family members and as well as these husbands, they are tortured to her. But at the time,
obviously torture. If she will not torture, why somebody will try to kill?
Yes, ma'am.
That part is there. Whether he has administrated the poison.
No, man. At the time of incident, husband was not there.
Not there.
Not there.
Petitioner is accused in so and so so. Allegation is different so and so. It is statement. Whose statement recorded? 164 statement recorded? No.
No.
The statement of the witnesses under 161 CRPC recorded by the police reveals that the petitioner was not treating well to his wife. The wife of the petitioner was completely dissatisfied in her marriage. On the date of incident, when she consumed the poison, however, the petitioner was not present at the spot. Petitioner is in custody since 29/10/2023. Regarding head to the nature of acquisition and the period of custody, is granted me. Yes.
Obliged.
Yes. 20. Yes. May I please, yours?
And already options under section 20B to C of
20?
20B to C.
Recovery?
45 kg, but petitioner was carrying 15 kg. That is the allegation.
CD is there?
Yes, ma'am.
Here was
Item number?
Huh?
Item number.
20. CD is there?
Yes, ma'am.
3976 of.
Yes, ma'am. CD is there.
In page 9.
Yes.
First column, last mail, घटना स्थल रे पहुंचबार
Custody, you tell me the custody.
Mail 19/3/2024.
Yes, 15 kilo, according to him.
Petitioner was carrying
Round.
15
No,
kg
sir.
on his head.
My lord, final PR has been submitted, my lord.
Total 45 kg, my lord. In the house, it was.
It is from him.
Total 45 kilo recovered.
Yes, my lord.
And 15 kilo
15
from
kg petitioner was carrying on his head.
And
Yes,
this is
ma'am.
correct. Very good. When it comes to the petitioners,
And my lord, 3 criminal antecedents of other, not similar to.
I mean, I'm not going into. You do your job and go. The encounter the petitioner submits that there are total recovery of 45 kilo of countable out of which 15 kilo has been recovered from. He has been in custody since 19/3/2020. Regarding to nature of regarding to the quantity of contraband recovered and the period of custody from 19/3/2024 when it will be subject to the
Obliged.
21. May I please? Custody since 25/9/2023,
25/9/2023.
so far as the petitioner is concerned, 201 allegation, my lord. Main allegation against one Kunna Naik. Allegation is that, my lord.
Yes.
My lord. My lord.
302. Yes. Charge sheet filed?
Yes, my lord. Charge
Yeah,
sheet
charge
filed
sheet
on
since long.
31/10/23, my lord. And petitioner was with
You
main
are
accused
Milu.
Kunna. My lord. My lord, may I read
Milishu.
one
Milishu.
164 statement, my lord?
Yes. 164 of
Oh, yeah, another
eyewitness.
witness, my lord.
Yes.
The ଶନିବାର ଦିନ ମୁଁ ଆଉ 3 ଜଣ ମିଶି ଗଣେଶ ମୂର୍ତ୍ତି ଡେକୋରେସନ ସାମାନ କାଢୁଥିଲୁ ସେଇ ସମୟରେ କୁନା ଦଳେଇ ଆସିଲା ମେନ୍ ପିଟିସନ ଆକ୍ୟୁଜ ମାଇ ଲର୍ଡ କୁନା ଦଳେଇ ଆସିଲା ମୁଁ ଓ ସେ ଯାଇକି ତା ବିଲରେ ତଳି ଖେଳିଲୁ ସେଇ ସମୟରେ କୁନା ମାଲିସା ଗୋଲାକୁ ଫୋନ କଲା ଆଉ କୋଉଠି ଅଛୁ ବୋଲି ଫୋନରେ ପଚାରିଲା ମାଲିସା କହିଲା ମୋର ଛେଳି ଗୋଟେ ହଜି ଯାଇଛି ସେ ସୁନୀଲ ପାଖରେ ମାଲିସା ମାଇ ଲର୍ଡ ଦିସ୍ ପିଟିସନର ମାଲିସା କହିଲା ମୋର ଛେଳି ଗୋଟେ ହଜିଯାଇଛି ସୁନୀଲ ପାଖରେ ବସିଛି କୁନା ତାକୁ ମୁଁ ତୋ ପାଖରେ ଅଛି ତୋ ପାଖକୁ ଆସୁଛି କହିଲା ଓ ମତେ ତା ସହିତ ଡାକିକି ମାଲେସା ସୁନୀଲ ପାଖକୁ ନେଲେ ଆମେ ସେଠି ଛେଳି ବି ସମୟରେ କିଛି ସମୟ କଥା ହେଲୁ କୁନା ହାତରେ ଗୋଟେ କାତି ଧରିଥିଲା ଓ ସେ କାତିକୁ ଗଛ ପାଖରେ 4-5 ଥର ମାରିଲା ଓ ତାପରେ ହଠାତ୍ ଗୋଟେ କାତିରେ ସୁନୀଲ ବେକକୁ ଚୋଟ ଦେଲା ସେ ଗୋଟେ କାତି ମାଡରେ ସୁନୀଲ ମୋ ଆଗରେ ସେଠି ମରିଗଲା ମୁଁ ଭାଇ ମାରି ଦେଲି କି କହିଲା ଭାଇ ମାରିଦେଲ କି କହିଲି ଓ ମୋ ଗୋଡ ହାତ ଥରିଲାରୁ ମୁଁ ସେଠୁ ଧାଇଁ ପଳେଇ ଆସିଲି କୁନା ମତେ କହିଲା ହେଲେ ତୁ ଆଉ ଆସିବୁନି ନହେଲେ ତୋତେ ମାରିଦେବୁ ସେମାନେ ଧାଇଁକି ମୋ ପାଖକୁ ମତେ ଟେକି ଟେକି ଆଣିଲେ ଆଉ କହିଲେ ତୁ ସୁନୀଲର ସେମାନେ ଗାମୁଛାରେ ବାନ୍ଧିଥିବା ହାତକୁ ଧର କହିଲେ ମୁଁ ଜମା ଧରିଲିନି ସେମାନେ ମଲା ସୁନୀଲ କୁ ବାନ୍ଧିକି ସେମାନେ ମାନେ ଦିସ୍ ପିଟିସନର and that Kunna.
Yes, he is not, but this man is not assaulted.
Not
No.
assaulted.
Yes.
ବାନ୍ଧିକି କେତେ ବାଟ ଟେକିକି ଝୋକାଡି ନେଲେ ଆଉ ବିଲ ଆଡେ ଟେକି ଟେକି ନେଲାରେ ମୁଁ ସେଠି ଦୌଡ଼ିକି ମୋ ଘରକୁ ପଳେଇଲି ସେ ଦୁଇଙ୍କ ଭିତରେ ଏକଥା କାହାକୁ ଭୟରେ ମୁଁ କାହାରିକୁ କହିନଥିଲି
Assault by
assault by
Kunna Dole.
sword.
କଟୁରୀ ଗୋଟେ
Katti.
And Katti brought by whom?
brought by Kunna Dole.
Kunna
Kunna
Dole.
Dole.
Yes, ma'am.
Then what is his role?
His role, he was present with
Present only, but after the murder committed by Kunna Dole, and he has tried to dispose of the
dead body.
301.
201.
Sorry.
201 is there, ma'am.
Except that there is nothing. Right on. Petition is accused in allegation against the allegation in the FIR is such.
Yes.
The statement of one of the witness, namely, who is that witness?
Witness
Witness, my lord.
Podilia person.
My lord. Krishna Pradhan.
One Krishna Pradhan was recorded under section 164 CRPC by the police, 164 during the investigation. He in his statement, and who the same witness is the eyewitness to the occurrence. He in his statement was stated that it is the Kunna what is that Kunna
Dole.
Called the present petitioner and one Sunil. What is his name?
That deceased name is Sunil Naik.
Sunil. He is called Kunna Dole called this petitioner and Sunil, both of them.
Yes, ma'am.
Over phone, isn't it?
Yes, my lord.
He has the Kunna Dole telephoned this man.
সেই সমୟରେ କୁନା ମାଲିସ ଗୋଲାକୁ ଫୋନ କଲା ଦିସ୍ ପିଟିସନର ପିଟିସନକୁ ଫୋନ କଲା ଆଉ ପଚାରିଲା ଯେ ତୁ କୋଉଠି ଅଛୁ ସେ କହିଲା ଯେ ମୋର ଗୋଟେ ଛେଳି ହଜି ଯାଇଛି ମୁଁ ସୁନୀଲ ପାଖରେ ବସିଛି ସୁନୀଲ ଯେ ଡିସିଜ୍ଡ ମାଇ ଲର୍ଡ
Okay.
ଦିସ୍ କୃଷ୍ଣ ପ୍ରଧାନ ସେଇ
Right on. Kunna Dole called the present petitioner. Called one called the present petitioner, who retorted that he is sitting with one. What is that?
Sunil Naik.
Sunil Naik, who is the deceased. Sitting with Sunil. Then both of them were called by Kunna Dole to the field. When they were interacting at that point in time, Kunna Dole suddenly gave a knife blow. Knife, what is
Katti blow.
Katti, inverted comma, Katti blow to Sunil. Sunil. To Sunil Shakam. Shakam. And after the death of, after killing Sunil, Kunadali, by the help of the present petitioner, tried to dispose of the dead body. From the perusal of the statement of the eyewitness and other evidences, it reveals that the present petitioner has not participated in commission of the crime. It is Kunadal who has assaulted the deceased, assaulted the deceased, and however the present petitioner has attempted to dispose of the dead body after the assault being made by Kunadal. Yes, Kunadal. The petitioner is in custody since 25/9/2020. Regarding head to the nature of accusation against the petitioner and period of custody, I am inclined to enlarge the petition with all conditions.
Oblige.
I'll just come. Yes.
That's a release of that laptop, my lord.
Item 6, no?
Item 6.
Yes, Mr. Das, item 6. And there are two matters they were waiting for you. Item 6.
Both the items pertain to for petition application. If your lordship permits, my lord, may I place that the Mr. Mishra case pass so that it will start with a positive note.
Okay.
Because
1 minute. What is that item?
Item 110.
110. And shorten your. He's saying, let us see.
Yes.
If you are satisfied with that, we may not be.
Yes, my senior has.
Then my lord,
100.
10.
10. Okay.
In this case, 25 lakhs rupees cash was seized.
Yes, I understand.
And petition not
if lordship permits, my
Remember,
lord.
yes.
If lordship permits, my lord, the entire thing revolves around so whatever lordship raised at particular points, that this particular money was kept in a particular room, bedroom, lords. But before I place what is the ultimate result of the truce, which in fact there is a hectic. I talked with the prosecution. He also talked with his clients, lords. Before I place what is the ultimate, lord, lordship may kindly note down my two submission, lord. Lordship may turn to this particular seizure list. Right together. The seizure list copied. I've given you 2 lines only, bro.
Yes.
Lordship can peruse that first line I put that 25 lakhs cash.
10 bundles of.
Lordship turn to the second line I highlight, lords.
Being asked about.
Another guy, lords, his name is Ramesh Chandra Sahu, lord.
Opinion signed disclosed the said amount to have been kept by Ramesh Chandra.
So another that the prosecution said that the prosecution's case is, my lord.
Who is the accused?
Accused is, my lord's main accused is.
I will just
go Tim.
I'll assist. Accused is one Ravi Panda. He is the daughter's father-in-law. The petitioner Gopinath.
I know that you are some.
And some.
What is the solution? I
40%.
Hearing, then I'll hear it later.
No, I'm not here. I'm placing any hearing matters.
40% indemnity bond.
1 minute. What is this?
My 2 line may be recorded. That's my lords. Milords, my first submission, milords, that particular amount was seized from the bedroom of.
That
1
minute. Bedroom of.
That the seizure list indicates that bedroom of that premises of Triveni, because 8 premises were raided on 14/11/2022. This is one of the place, and it was recovered. And 1 month. And second, my lords, the prosecution said this is the crime proceeds, my lords. And we got intelligence report, I read it at my lords. The second point,
He's making, he is not entitled to make a submission also.
no, ultimately we will reach in the same conclusion. But
Wait,
there are certain submission I have to record
holding a
it.
brief here to tell.
My senior said, my lord,
No,
yes, without recording submission, just now spoken.
And if you want a hearing, I can't sacrifice bail matters. I'll hear it after 5.
Lords, 2 minutes, lords. Lords, you may kindly record mine that this was seized such places, lords. The another guy, lord,
I understood it next.
Ramesh Chandrasawi said that
It was recovered from the house of the petitioner. It was kept by.
No, not in the house, in the bedroom of where one of the accused, the father, son, and the wife, lord. The son's bedroom, lords. That his wife and son were there, lords.
Yeah.
The another guy, this Ramesh Chandra Sahu, he said that this belongs to me, lords. And then the petitioner Gopinath Sahu, lord, the Samudi, he filed an application. This belongs to me, lord. In this particular scenario, lords, what I suggest, lord, the
who was this petitioner Gopinath?
The Samudi of the main accused.
Gopi claims.
Gopi claims that it belongs to him.
And who else?
Then Lord Ramesh Chandra Sahu that it belongs to him. When subsequently filed an affidavit that it doesn't belong to me.
Ramesh Sahu is who?
Now, you'll also turn to page 46 of that.
Who is he, Ramesh Sahu?
He's another guy, friends of the Samudi.
Accused.
A friend of the Samudi.
Gopinath Sahu, he disowned and vigilance
Family
recorded.
friend.
And he's filed
Family friend.
Family friend.
And
he filed an affidavit saying that now subsequently said that this doesn't belong to me.
Affidavit is part of record?
Yes,
page 46, Mullers.
Yes.
Page 46.
Okay. I understood it. Now,
Yes.
you tell me now.
Now, the 3 persons are in the frame, lords, claiming this particular that which belongs. And the prosecution said this is just crime proceeds of out of that D amount, lords. This is one of the parts, lords. And it was read in early morning, lords. So
that is the reason he has to give indemnity fund.
So that's why, lord, my suggestion is, lords, initially, lords, with regard to the bank guarantees, lordship 50% and 50% indemnity bonds, lords. Because of the peculiar factors of contract. My learned friends.
I don't dispute about my senior submission. Let it be not 40% of the bank guarantee and 60% indemnity bond. Delhi High Court has said you'll also
dispose him. Allow Delhi High Court.
Anyway,
dispose it.
You'll also dispose of.
Thank you. Put it as.
And my lord, one submission, my submission maybe kindly will record it. One submission, I will not take much time.
40 bank guarantee, 60 currency,
46.
40 is a bank guarantees and 60% indemnity bonds.
Yes. And your lordship may record one submission, annexure 3 series, statutory audited balance sheets that may be recorded.
I will not say anything on that.
As your lordship.
Then I'll have to reject it.
No.
No, in fact, he also talked with the class, the truth was possible because
because there are 3 claimants. And that is why I am taking indemnity bond. Bank guarantee.
Yes, you also made
if
arrangement.
anything goes wrong, then
you are obliged, my lord. You also made arrangements. Challenging the order dated 22nd July.
Come to item 6.
Yes.
Yes.
Come to item 6.
Obliged, my lord.
Item 6.
Yes, my lord. This is that case, lordship, to refresh.
Yes, the son's
to refresh your lordship memory, this is that case. Laptop was seized,
I know the.
And my learned friend, my lord, being apprised by his clients, my lord, he was desperate that he will lose the job unless and this is seized. This is really seized. I'll have to release, my lord. Well, I've got the instruction, my lord, but it will take some time. I'll place it because of his. It's a cryptocurrency matter, my lords. I've got the total instruction. It will take some time, lords. Lords, we take it after lunch, my lord. Because after lunch.
Yes. Come to the. No, I'm taking bail matter. These are the 2 matters because they were waiting. Passport, I'll take it. Are you going somewhere? He's going somewhere. It is an exception. Don't mention because he's a senior person, so therefore I'm entertained. Yes. Youngsters can wait.
When upper senior?
No, senior
for quite young.
Senior man, not senior designated.
Yes.
In custody since 8/6/22.
This is a bail application.
Bail application.
Yes. Custody since
8/6/22.
8/6/22.
My lord.
What are the allegations?
POCSO is there. 376.
Last petition, my lord. On 13 my lord, victim appeared before the virtual my lord.
Refused to marry.
13-8.
Why don't you deputy one of your juniors to tell? I would have dismissed it. Nobody was there.
I'm
Yes,
sorry.
anyway.
I'm sorry.
She identified and inquiring from the court. She has.
They were in law. Primarily, they were in law.
She's not interested.
Not willing to marry.
And she's also
That
intimate.
is what she had submitted last time.
Not intended. Neither the family member nor the. Next.
Victim my lord, 15 years age my lord.
Yes.
Yes.
And
Come to the merits.
Murder.
Come to the merits. Yes.
Admittedly, they
What
were
is the age of this boy?
Boy is 22.
22. And he is in
Admittedly,
custody?
15. At the time of occurrence.
22. Yes. Read 164.
My lord.
Yes.
such and such 9/6/2022 ରେ ମୋର ମୌଖିକ ହେଇଛି 2 ବର୍ଷ ହେବ ମୁଁ ଏମଭି ନନ୍ଦନ ଭରାନୀକୁ ଭଲ ପାଉଥିଲି ସେ ମଧ୍ୟ ମତେ ଭଲ ପାଉଥିଲା କିନ୍ତୁ ଆଜକୁ ପ୍ରାୟ 6 ମାସ ହେବ ଆମ ଭିତରେ କୌଣସି ସମ୍ପର୍କ ନାହିଁ କାରଣ ମୁଁ ତାର ଖରାପ କ୍ୟାରେକ୍ଟର ବିଷୟରେ ଜାଣି ପାରିଲି ତା ପାଖରେ ଆଉ କିଛି ଜଏଣ୍ଟ ଫଟୋ ଥିଲା ସେ ତାକୁ ଭାଇରାଲ କରିଦେବ ବୋଲି କହି
and section
306 custody
and my lord custody since 14/3 to 2024 my lord
14/3
2024
2024 14/3/20
on last
yes.
occasion my lord your lordship
your husband
yes my lord on
yes.
last occasion my lord your lordship wanted to know under what circumstance the deceased died my lord
yes.
As per the PM examination report my lord that I have annexed that the victim cause of death is organic phosphorus poisoning my lord and the taking poison my lord my lord and
who administered the poison
my lord and as per the independent witness my lord two independent witness my lord they disclosed during investigation my lord the victim was deceased was lying in the
complainant
medical in the Machigori temple premises my lord in a unconsciousness my lord thereafter she was shifted to medical and during treatment my lord she died my lord as per the statement of one D. Shravan Kumar
my lord that who is the complainant my lord Santi Sabar my lord that is a 2-page 164 statement my lord I'm just reading the major part
relevant part
major part is regarding the torture of and another one is just I'm reading two lines man
torture kala boli se
ଆମେ ଥାନାରେ ପହଞ୍ଚି କରି ଆମେ ଦେଖିଲୁ ଯେ ମନ୍ଦୋଦରୀ ସେଟାକୁ ମଧ୍ୟ ଯାଇନି ଆମେ ସେଠାରେ ଥିବା ସମୟରେ ମନ୍ଦୋଦରୀ ମୋତେ ଫୋନ କରିଲା ଆଉ କହିଲା ଯେ ସେ ରାୟଗଡ଼ା ମାଝିଘାରୀ ମନ୍ଦିରରେ ଅଛି ତାକୁ ଭଲ ଲାଗୁନି ସେ ଆଉ ମଧ୍ୟ କହିଲା ଯେ ଶ୍ରୀକାନ୍ତ କନେଷ୍ଟବଳ ରମେଶ ଶ୍ରୀକାନ୍ତ ହଉଛି ଦିସ୍ ପିଟିସନର ହଜବ୍ୟାଣ୍ଡ କନେଷ୍ଟବଳ ରମେଶ ଆଉ ଜଣେ ତାକୁ ମେଡିସିନ ଖୁଆଇ ଆଣିକରି ମାଝିଘାରୀ ମନ୍ଦିରରେ ବସେଇ ଦେଇଛନ୍ତି
but in the investigation report my lord the investigation report the Ramesh Behra his name has been deleted my lord the I have mentioned in the investigation his name has been deleted and this
is a kind of dying declaration
my lord
the lady who has died
my lord
immediately before death she has disclosed this fact that it is you who has given the medicine
my lord
so therefore unless this witness is examined you can't
but my lord investigation my lord that accused name has been deleted my lord in the charge sheet
he's lucky
my lord in the charge sheet my lord the IO has mentioned the detail
because he was policeman
no my lord
yes
that is not the thing
he is a police guy
no they are the interested witness but the independent
he is a police who is police out of them
both are constable both are constables he was the another person my lord
he was trying also be dropped because your husband they could not do anything so therefore they could get that other constable out right now the petitioner is accused in so on petitioner was the husband of the deceased the statement of which witness is that name
Santi Sabar
statement of one Santi Sabar
who is the complainant of this case complainant of this case
who is the complainant in the case has been recorded under section 164 CRP she in her statement has stated that the petitioner has been not treating well to his wife and has been constantly tortured. On the date of incident, the deceased has informed her that she is in the Majigarian temple. She is sitting in the temple and not feeling well. And she has also informed that the present petitioner and one, what is the name?
Ramesh Kumar Behera. Ramesh Kumar Behera.
Present petitioner and one Ramesh Kumar Behera.
Present petitioner.
Yes,
Petitioner Ramesh Kumar Behera. I mean, he
had given some medicine to her, and after taking those medicine, she is not feeling well. Subsequently, she died. The medical evidence produced before the PM report submits. PM report reveals that the death is due to poisoning. Death is due to poisoning. Mr. Mishra and counsel for the petitioner submits that although in the 164 statement, the informant has specifically alleged against the petitioner as well as that what is the Ramesh Behera.
Ramesh Behera.
Ramesh Behera. However, in the charge sheet, the name of the Ramesh Behera has been dropped. Be that as it may, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the informant. What is its name?
Santi Savar.
Santi Savar is examined by the court. The trial court is directed to do well to see that the informant is examined as the first witness, giving preference over all other witnesses.
23.
My lord, item 23, I have filed a interim application. I have filed an interim application.
Yes.
The IA 11/80/2024.
Yes.
On 10th September 2000.
Custody?
Custody
Custody
since
matter 24 to 24.
24.
This is
24
24 to
24.
24 to 24.
Yes.
A 2013 matter. And he was the absconder, his custody NBW issued, and he was arrested on 24 to 24.
Sorry, no?
What about the other accused person?
My lord, two persons have been granted anticipatory bail. I showed your lordship in the previous date. Therefore, lordship directed the state council to take instruction over the matter, whether the two persons, namely Hari Sahu and Achyuta Sahu, are similar, they are lying similar footing with the
Role
petitioner.
of the
Yes.
petitioners, those
So
who have
that
granted
I wanted to show you to your
and
lordship.
his role.
Yes.
Oh,
Your lordship may
yes.
kindly see page 10. Your lordship may kindly see page.
Yes. Page 10.
Yes.
Yes.
Your lordship 13 lines before the besides, it starts from besides.
This is FIR.
This is the affair. This is the NDPS case, my lord, the affair and
Yes,
all
yes,
the mine.
Yes.
Besides one, Rajkishore Behera is the neighboring of Benudhar Sahu of the same village. Benudhar Sahu, Rautray Sahu, Achyuta Sahu, Hari Sahu and Rajkishore Behera, all are of village Nuaga, Telisai, have kept a huge quantity of contraband ganja in the middle room of the bedroom of house of Benudhar Sahu.
Who are you? Benudhar.
I am not the
Mr.
Benudhar.
Rajkishore Sahu.
I am Rajkishore Sahu. So other person, two persons, my lord, that I had shown to your lordship, Hari Sahu and Achyuta Sahu, they are the similar footing.
Similar footing, but they have not absconded. 2013 you have.
No, my lord, anticipatory bail was granted. I was also I was the petitioner. I was the petitioner. I was moving to the High Court times and again anticipatory bail. After rejection, my lord, I was
My
arrested.
lord, the Benudhar Sahu as a present petition, they are both brothers.
Well, but it is in the house.
From the Benudhar Sahu house.
You tell me from 2013 onwards, where were you? You simply tell me that.
My lord, I had filed one anticipatory bail.
When have you filed?
Along with the two persons. Along with the two persons.
Your
who have been
application
granted.
was rejected.
My application was rejected. Two are allowed bail. But I was.
When was it rejected?
It was rejected, my lord, on 22/11/2013.
13.
Subsequently, my lord, I have moved.
After a decade, you came.
No, my lord, after that, my lord, I had filed another bail application.
When you give me the details.
Yes, your lordship. Your lordship may kindly see another bail application was filed, my lord, by the petitioner.
First bail application rejected 2013.
Then the 2016.
16.
My lord.
After 3 years.
After that, but police didn't come to my house.
Then that is rejected.
That is rejected.
When?
My lord, that is rejected that is withdrawn in fact.
Withdrawn.
8/2/43 of 2016. That is 5/8/2016.
16. From 16 to 2000, when this petition is filed? This petition is filed.
I am arrested in the year on 14 to 2024.
24.
My lord, but
16 to 24.
But I am in the house. The police will not come to me for arrest.
That's not the ground.
If my lord, police will not come to me, my lord, for arrest.
But fact remains
How
that
many witnesses are examined?
That instruction,
my age is your lordship may kindly see.
Case is splitted up.
Must have been split up.
No case he has not.
Huh?
No,
whether it was splitted because the other.
No. Your lordship may kindly see rejection order. 2023 warrant was issued. Your lordship may kindly see that. Okay, please.
Against the petition, sir, whether it is the other people might have faced the
No,
trial.
along with me. Your lordship may kindly see this.
The trial is not proceeding at all.
No, not.
Call for a report for regarding the status of the trial in regard to the FIR number so and so forth.
That means charge sheet must have been filed in the year
Let us
2023.
Let us see. You might maybe the reason for delaying it for.
No, not at all. Not at all. But your lordship may kindly see that the third paragraph, fourth paragraph.
Let me get the report.
Your lordship may call for the report. That
Let me see.
your lordship may kindly see page 70. Page 70.
Since I am calling for a report, today I am not, in any case, I am not giving you. If you want rejection, I'll reject you. Wait, let us see. If you are responsible for delaying for more than a decade, then you are not entitled. Otherwise, you are entitled.
Yes.
Otherwise,
your lordship may kindly see warrant was issued on 17/10/2023.
Let me see the.
It is mentioned, man. It is mentioned in the order.
I understand if you are not there, the matter is adjourned. Those people were on anticipatory bail. They must be asking for adjournment.
Soon after filing of the charge sheet, warrant will be issued. Soon after filing of the charge sheet.
I don't know whether soon after it is done or not.
That is the procedure.
Charge
sheet will be filed, cognizance will be taken, warrant will be issued.
You have decided one thing that this you want to go to trial court. I think. Wait.
You lordship may call for the report, but I wanted to show, my lord, that 2020.
After two.
Diploma.
Call for a report.
Sir, your lordship date maybe.
Date will be.
Next week.
Give it a specific date. Don't worry.
Yes. Before vacation, your lordship.
I'll see. Yeah. You could
May I
avoid
please
for
your lordship,
2 decades, about 1 decade. Why can't you wait for 1 week?
Old man, my lord, since 14 to 2000. Sometimes, my lord, police is actually not taking any steps for arrest. Sometimes.
Let us see. Understand. Yes.
Your lordship may verify that.
25.
May I please your lordship?
Yes, sir.
My lord, the petitioner is in custody since 7/10/2023, my lord.
7/10.
302 CD requirement.
CD call. Yes.
I fix a date, my lord.
May it please, your lordship.
Yes.
Now, the petition is in custody since 4/11/2023.
4/11?
2023.
Yes. Yes.
And the allegations are under section 498A 304B and 306 of the IPC.
Yes. How she died? You are the husband.
She consumed poison. I'm the husband.
Show me. You administered the poison or
No,
he herself taken?
My lord, there is no allegation with respect to the fact that I administered the poison.
Yes.
She consumed the poison and.
Yes.
she was taken
Show me
by-
something.
My lord, the viscera, it was preserved for viscera, PM report. There is one injury, that is bone injury on the right wrist. Right wrist of the deceased.
Right?
Wrist,
Yes.
madam.
Knees.
Wrist, madam.
Okay.
And the viscera report was preserved, madam.
Burn injury.
Bone injury in the right, in the injury part, my lord, there was bone injury. But allegation is poison.
Poison.
So viscera report was sent for reserve for viscera.
No, let us presume that it is poisoning. Whether
And he was treated at hospital on 30/11/23 to 3/12/23.
Any statement recorded?
No, my lord. Dying declaration was not recorded. And my lord, the neighbor, my lord, they have stated that deceased has taken poison because deceased has voluntarily taken poison. Or the neighbors, they have stated.
And with respect
And
to
the
the injury.
brother, my lord, who is also stated, my reading the statement of the brother, my lord, of the deceased. ଯେ ମୋର ଭଉଣୀ କି ରିଲିଭେଣ୍ଟ ପାଏ ତା ମୋର ଭିଣୋଇ ତାଙ୍କ ଘରକୁ ନବାର କିଛି ଦିନ ପରେ ତାର ପ୍ରଥମ ସ୍ତ୍ରୀ ତା ଛୁଆଙ୍କୁ ଧରି ତାଙ୍କ ସାଙ୍ଗରେ ରହୁଥିଲା 1/12/23 ଦିନ ମୋର ଭିଣେଇ ମୋର ବାପାକୁ ଫୋନ କରି କହିଲା କି ତମ ଝିଅ ବିଷ ଖାଇଦେଇଛି ବିଷ
Protham Stree means he is another.
He is second wife, my lord. Present
And
the deceased
first wife is also there.
First wife, my lord, he is staying in her parents' house due to some torture and
they are separated. First wife.
No, my lord.
Legally they were not separated.
Then you have to wait.
Legally they were not.
Wait, adjourn it beyond 4th November pore 1 year. You are habitual. You have created problem for first wife, and she is there, and second wife commit suicide, and so therefore you wait till at least 1 year.
Your Lordship, may
After
kindly
4th November, reached after 4th November.
27.
May I please?
Yes, sir.
My lord, item number 27 and item number 30, both are
27, 30.
30.
Yes.
Both are same.
Same means same FIR.
Same.
Two accused.
Yes.
Okay.
My lord, in item number 27, that is 4823 of 2024, all two of the petitioners are ladies, my lord.
Okay.
And my lord, in the other bail application, the
You
petitioners
tell
are
the
the
ladies first. Ladies thing.
Okay.
They are in custody since
They are in custody
16/3/24.
16/3/24.
24.
Okay. What are the allegations against?
My
those
lord,
ladies?
allegation part, my lord, that is as per the statement of one that is complainant, that is Buttuli Santo. He had stated that ମୋର ମା ସହ ତା ଆଈ ଡମାଇ ଶାନ୍ତ ଭାଉଜ ରମା ଶାନ୍ତ 4 ଜଣ ଛୋଟ ରହୁଛନ୍ତି ଆମ କେନ୍ଦୁଗୁଡା ଗ୍ରାମର ଲୋକମାନେ ମୋର ମା ରଇବାରୀ ଶାନ୍ତକୁ ପଙ୍ଗିଆଣୀ ବୋଲି କହି ଗଣ୍ଡଗୋଳ କରୁଛନ୍ତି ବ୍ଲାକ୍ ମ୍ୟାଜିକ କରୁଛନ୍ତି ଏଇ ବିଷୟ ମୁଁ ମୋ ମା ଥାନାରେ ଯାଇ ରିପୋର୍ଟ କରୁଥିଲୁ ପୁଲିସ ଆଉ ଆମ ଗାଁ ଲୋକଙ୍କୁ ଡକାଇ ବୁଝାସୁଝା କରି ଆମ ପରିବାର ସହ ଗଣ୍ଡଗୋଳ କରିବାକୁ ମନା କରି ଧମକ ମଧ୍ୟ ଦେଇଥିଲେ ଗତ 7/3/2001 ରାତିରେ ମୋ ମା ଝରି ଗାଁରୁ ଘରକୁ ଫେରିବା ବାଟରେ ଆମ ଘର ପାଖରୁ ଆମ କେନ୍ଦୁଗୁଡା ଗ୍ରାମର ଆମର ସମ୍ପର୍କୀୟ ହେବେ ସାରଥୀ ଶାନ୍ତ ମୁଗୁରି ଶାନ୍ତ ପ୍ରହ୍ଲାଦ ଶାନ୍ତ ଲକ୍ଷ୍ମୀ ଶାନ୍ତ ମାତରୀ ଶାନ୍ତ ଓ ମୁଗୁରି ଶାନ୍ତର ସ୍ତ୍ରୀ ଚମ୍ପା ଶାନ୍ତ ସାରଥୀ ଶାନ୍ତର ସ୍ତ୍ରୀ କାଜଲି ଶାନ୍ତ ମିଶି ମୋର ମାକୁ ବାଟରୁ ଟାଣି ଟାଣି ତାଙ୍କ ଘରକୁ ନେଇଗଲେ ତାଙ୍କେ ଆମକୁ ଗଣ୍ଡଗୋଳ କରି ମାରିବେ ବୋଲି ମୁଁ ମୋର ଭାଉଜ ରଦମା ଶାନ୍ତ ଆଇ ଡମଇ ଶାନ୍ତକୁ ଭୟ କରି ତୁନି ରହିଗଲୁ ପରେ ସେଇ ଦିନ ଠାରୁ ମୋର ମା ଘରକୁ ଫେରିଲା ନାହିଁ ଆମେ ତାକୁ ଖୋଜାଖୋଜି କରି ପାଇଲୁ ନାହିଁ
Your name is there. You have pulled them
This
out.
is due to witchcraft. They are suspecting witchcraft.
Yes.
Conceal the dead body. And on the instant of other 2 accused persons in the connected matter, in the instance of
they have confessed before the police
dead body was recovered, my lord. And the complainant, who is the pre-occurrence witnesses, also last in theory, my lord. They have specifically named the present petitioners. They are asserted and they also taken.
No, then let the complaint be examined.
My lord, may I pray? The ladies may be considered.
No, ladies are important. You don't know the. In that
Ladies have not assaulted, my lord.
Nobody has seen who has assaulted.
My lord,
These 2 ladies were there in that group to take this.
They take the disease as they were related to each other. They take the disease to their house, and thereafter.
Who has given assaulted? Nobody knows.
Yes, that is there in the 27 statement, my lord, of one Muguri Santo. That is there. ଯେ ଆମ ଘରକୁ ଆସି ଧମକ ଦଉଥିଲା ସେଇ ସମୟରେ ଆମର ମୁଁ ଓ ମୋର ପୁଅ ମାନେ ପାଇକ ଶାନ୍ତ ଘର ଶୋଇଥିଲୁ ଆମେ ତାକୁ ମାରିଦେବାକୁ ନଚେତ ସେ ଆମ ଲୋକକୁ ଗୁଣି କରି ମାରି ଦେଇଥାନ୍ତା ଆମେ ତାକୁ ରାସ୍ତା ଉପରେ ଧରିଲୁ ପାଇକ ଶାନ୍ତ ଧରିଥିବା ପାଇକ ଶାନ୍ତ ଧରିଥିବା ଗାମୁଛାରେ ତାର ବେକରେ ଟାଣିଲୁ କିନ୍ତୁ ସେ ମରିଲା ନାହିଁ ପରେ ମୁଁ ତାକୁ ଧରିଥିବା କାତିରେ ତା ବେକ ପାଖରେ ଚୋଟ ମାରିଲି ଆମେ ତାକୁ ମାରି ଦେଲୁ that is one of the petitioner, that is Muguri Santo. He is petitioner in
Muguli saying
in whose instance dead body also.
Yes,
Muguli and Paiko. And what about Sarathi?
Sarathi has not assaulted. Muguri and Paiko have assaulted as per the yes, that is 27.
Participated in the offense. They have taken these present petitioner, 2 petitioners, first petitioner, the ladies. They have taken the disease.
Along with others. All of them.
But see, these 2 ladies have taken this disease. Along with that, many names have come.
Yes.
They are not accused.
No.
All are accused, my lord.
All are accused, my lord. Muguri, Paiko, and Sarathi, all were accused.
These 5 people.
Yes.
5 people named.
Yes.
They are in connected matter.
I am not now interested for my lord the gents person, my lord. because Lordship may pass appropriate order. I only pray to consider the ladies, my lord.
What do you say? Because see, 27, if you believe, in 27, the gents have assaulted.
Muguri and Paika.
But these people have taken.
Yes.
And they are in custody since about, no, it's not even a.
Contrary, 16/3/24.
No, 11/3/24, the ladies member was arrested.
11?
11/3/24.
Yes.
Small kids are there, my lord. Let the lady members be
No,
considered.
you tell me, 32 years, Champa.
Yes.
How many children are there?
My lord, two children, my lord. Champa has got 2 children and Kajoli has got 1 children.
Minor.
Minor children. Choto chua guda gore. He kona ho.
Where have you said that?
Where
Where have you said that?
That is my submission.
Show me from your petition, at least some pleading somewhere. I'll record that.
Lordship may record, my lord.
You see,
I don't.
So far as the gents members are concerned, I'll go by 27.
Yes.
And since the
Assault part by the
assault part by them, and these ladies, because of 2 reasons. One, their lady, they're in custody since March 24.
2 persons are ladies.
These 2 ladies, I'll let them out and I'll make observation insofar as.
Well.
The petitioners are accused in so allegation in the FIR is so. The prosecution is relying upon the circumstantial evidence. Primarily, prosecution is insofar as the present petitions are concerned. Primarily, prosecution relies upon the prosecution alleges that these 2 ladies have called the deceased to the place of occurrence on the right. Subsequent thereto, the bench members, namely, what are the names? Namely,
Muguri and
Sarathi.
No, Sarathi, I am Marini. Muguri or Paiko Marle.
Sarathi, Muguri, and Paiko were accompanied, were present in the spot. After arrest, Muguri Samanta has made disclosure statement leading to recovery of the dead body. See, the Muguri Samto in his disclosure statement under section 27 Evidence Act.
Along with my dead body, along with the crowbar and spade. That was
dead body and the
crowbar and
weapon of and the said accused in his statement under section 27 CRPC has also stated that he and Paiko he and co-accused Paiko have assaulted the deceased by means of
spade and
crowbar.
To which the deceased succumbed. Since the prosecution is relying upon the statement of the relied upon the disclosure statement of the co-accused heavily, and the last in theory. I am not inclined to enlarge Muguri Samanto, Paiko Samanto, and Sarathi Samanto, the petitioner in BLAPL number 4994 of 2024 states. However, liberty is granted to them to renew their bail plea after the material witnesses are examined. In next part, insofar as the petitioner Champa Samanto and Kajoli Samanto in BLAPL number 4823 of 2024 is concerned, both these petitioners are ladies of 32 years and 35 years respectively. Mr. Mishra and counsel for the petitioner submits that they have both of them have 2 minor children. Allegation against them is only the last in theory, inverted comma last in theory. if the statement of the disclosure statement of the co-accused is to be believed, then these two lady member who has accompanied the principal accused have not assaulted the deceased. In that view of the matter, the petitioner, the present petitioners, being a lady, present petitions are entitled to bail. Regarding head to the nature of evidence collected by the police against the present two petitioners, and the fact that the petitioners are lady member having children, minor children, and they are custody since 11/3/2024. I'm inclined to enlarge the petition, the present petitioners. Inclined to enlarge the petitioner in BLAPL number 4823 of 2024 on bail, while rejecting the bail plea of the petitioners in BLAPL number 4994 of 2024.
Oh, bless.
Yes.
28.
Yes. 30 pole na? 28.
Present bail application page allegation against offences 304B, 306, 419A, and
Custody?
charge sheet is submitted.
Custody
since 19/12/2023.
19/12/23.
2023.
Okay.
And the present.
You are the husband?
No.
Mother-in-law.
Present petition.
Mother-in-law.
Mother-in-law.
What is that?
Next item is husband.
Who is husband?
Next item.
Okay.
That the charge sheet submitted by 498A, 304B, 306.
Yes.
And 4PP.
What is the allegation against the mother-in-law first?
All the
You are
witnesses-
opposing?
Yes.
Yes.
And all the witnesses, they have stated that
Torture.
only torture.
Torture, it's all right. Torture.
And my executive magistrate, her statement is that though there is hanging, antemortem hanging, but the rope was not at the time of when the dead
But
body
there
was
was a
recovered,
cotton
the rope was
cloth,
not
my
with the
lord.
dead.
There was a cotton cloth.
The minimum thing is, I must tell you one minimum thing is, one lawyer speaking,
I'm sorry.
don't speak. Because you get the opportunity.
My
This is bad manners
I'm sorry.
in the courts. See, he's saying something. And thereafter you speak, you clarify that. What is the big deal? Yes.
And dead body was found at the kitchen. When the inquest report was conducted. At that
And
time,
the hanging takes place inside the room.
inside the room.
Who
Then
has
after-
who has brought that dead body?
The witnesses, they have stated that when they have seen, at that time, they have already, that the dead body was at the at kitchen,
In
but
the
no rope was there. That is the suspect. Because usually in the presence of executive magistrate, inquest report was made. See also, I am reading that portion that she has
Yes, yes,
stated.
I believe that. Yes, madam.
Husband
How-
is, my lord, is not entitled.
Huh?
Your husband is not entitled. Your mercy may pass that order, I guess, that the
Take
mother-in-law-
50%.
mother-in-law only Alex.
My lord, when the
See how the dead body from the room this
the
has
room
happened.
was closed where she committed suicide. It is the.
And how after death,
So
how
the
she
death-
came out?
No, when the death was it is due to the asphyxia, my lord, where medical.
I understand that.
No,
You just
first-
explain me if the hanging has taken place inside the room, how the dead body has
No,
come
hanging
to.
was taken place. It was closed, and the mother, the deceased, the husband of the deceased and the mother-in-law of the deceased broke the door and took the dead body from that door to kitchen, my lord.
That's
But
the
once
problem.
cotton cloth is there,
That's
they
the-
show the cotton cloth to all the informant and all the relatives.
Where from you get all these things? Show me.
Sorry, my lord.
Show me where from you get this.
That is, if your lordship see the informant, the complainant statement, my lord. Should I read out?
Yes.
my lord?
Relevant part.
ଆମକୁ ସନ୍ଦେହ ଲାଗୁଛି ନା ମୋର ଝିଅ କେବେ ହେଲେ ଆତ୍ମହତ୍ୟା କରିପାରିବ ନାହିଁ, ତମେ ତାକୁ ମାରି ଦେଇଛ, କେଉଁ ଦେଉଳରେ ମରିଛି ତାହା ଆମକୁ ଦେଖାଅ ବୋଲି କହିବାରୁ ସେମାନେ କିଛି ଦେଖାଇ ପାରିଲେନି, ଏଣୁ ଆମକୁ ସନ୍ଦେହ ଲାଗୁଛି ସେମାନେ ଆମକୁ ପୁରୁଣା ଗାମୁଛା ଦେଖାଇଲେ, ଏହି ଗାମୁଛାରେ ସେ ବେକରେ ଲଗାଇ ମରିଛି ବୋଲି କହିଲେ ଯେଉଁ ଗାମୁଛା ଦେଖାଇଲେ ସେଥିରେ ଗଣ୍ଠି କିଛି ପଡିନାହିଁ, କେମିତି ଏହି ଘଟଣା ଘଟିଛି ତାହା ମଧ୍ୟ ଆମକୁ ଠିକରେ କହିଲେ ନାହିଁ, ଏହା ମତେ ସନ୍ଦେହ ହେବାରୁ ମୁଁ ଆଜି ଥାନାକୁ ଆସି ରିପୋର୍ଟ ଦେଉ
That's the problem, madam, with this. That's the only problem.
they showed the cotton cloth by which
Okay, where the hanging has taken place? Where in the room? Why the dead body was brought from that room to kitchen? And the rope is also not there.
And if they have
Whether
taken-
in that
but
towel.
the medical report said that it is the death is due to asphyxia, my lord.
I know you might have done it. That's the whole difficulty to know.
We were not there. We were not there when she committed.
You find
suicide.
out the best point in you. You are arguing against yourself. You find out the best point.
If they have got that rope, it is his duty that he should take the deceased to the hospital. Why they are keeping that dead
No,
body,
at that time when
kitchen.
we reached there, she
Kitchen.
was already dead.
questions?
She was
Any
already
questions?
dead, my lord. At that time when we reached there, I was in my garden to collect the vegetables, and the husband of the deceased was gone.
Don't
for
tell
his
me
work.
story, madam, on the basis of the evidence you tell. In the bail stage, I can't believe your story.
My lord,
Oral story. You tell me from the evidence.
so far as the inquest, that is the report of executive magistrate, ମୃତ ସ୍ତ୍ରୀ ଲୋକର ବେକରେ କଳା ଦାଗ ଥିଲା ଏବଂ ଶରୀରରେ କୌଣସି କ୍ଷତ କିମ୍ବା ଚିହ୍ନ ଆମେ ପାଇଲୁ ନାହିଁ। ମୃତ ସ୍ତ୍ରୀ ଲୋକର ଶାଶୁ କିମ୍ବା ମୌତ ସ୍ତ୍ରୀ ଲୋକ ସ୍ୱାମୀ ଜଣକ କିଛି ଜଣକ ଉତ୍ତର ସ୍ତ୍ରୀ ଲୋକର ବାପା ମା ସନ୍ତୋଷଜନକ ଉତ୍ତର ଦେଇପାରିଲେ ନାହିଁ। ସେ ଦୌଡ଼ି ଦେଇ ମରିଗଲା ପରେ ଶବକୁ ସ୍ୱାମୀ ବାହାର କରି ରୋଷେଇ ଘରେ ଶୁଆଇ ଦେଇଥିଲେ। ସେମାନେ
ପଚାରୁଛନ୍ତି କୋଉଥିରେ ମରିଛି ଇଏ କିଛି କହିପାରିବେ।
ସେଟା ଟିକେ କାମ ଛୋଟ ତ ଦେଖିକି
But why 306 you filed?
that is the cotton.
Why
306? So there is antemortem hanging. For that reason, police has filed 306.
You could have filed 302 also. In these circumstances, it
Yes,
will be
yes.
302 only.
Fine. The managed. I mean, where there is hanging, police naturally. That's it.
That time
Hanging, but see, hanging, nobody knows it, whether it is hanging, it is murder. Nobody knows. There is a gap in between. Wait, after 2 weeks, I'll give to the mother-in-law, not to the husband.
Then you'll
Wait after 2 weeks, huh? After 2 weeks. I'll grant mother-in-law being a lady, she is about 50 years of age. I'll grant bail and not to the husband.
Like
very weak kind of evidence. Or if you can find out something, please help so that we can do it. Okay. After 2 weeks. Yes. 22, 20. Both the matters.
Okay.
31. You find out the best thing, yeah? Best point in you.
30 arjun is
20. Common order.
May I please, your lordship?
Yes.
Lordships, the petitioner is a 25 years old boy
Yes.
who is in custody since 27/12/2023.
27/12.
2023.
23. Okay.
Being charged sheeted for an offense under section 498A, 304B, 306 and 34 of IPC.
Yes.
The petitioner is the husband of the deceased, your lordships. This is a case of suicidal hanging.
Hanging.
Your lordship.
Show me that part.
Which
How? Show me that part.
suicidal hanging, anti-PM is suicidal hanging. Charge sheet also under section 306. Though allegation is made that physical and mental torture, but investigation,
forget it.
but investigation reveals that they are quarreling due to proper care of that newborn baby. For that reason, she has
bolted door from inside. Anything
Yes, yes, my lord. Statement, my lord, I am reading. One neighbor, my lord, he has given.
Read it.
Relevant person. उमेश मुदुली ता माँ संजुप्रिया मुदुली केही ताको गृह कार्य साहाय्य करनथले ताଙ୍କ परिवार घटना दिन 27/12/23 को सकाळ समय बिल काम करिया पय पाख बिल जायतिले उक्त दिन सकाळ 8:30 घटिया समय वर्षा रानी साहू एपरि निर्यातना सही न पारी ता रूम भीतर पटु कबाड़ देई पंखा साडी रो
Okay, okay. The statement of the witnesses recorded by the police under section 161 CRPC was read out extensively at the back, and it reveals from the statement it reveals that the petitioner was the husband of the deceased. They were their relationship being husband and wife was not happy. On the fateful day they had a quarrel. Quarrel as the deceased was not taking care of the child, taking care of the child. The deceased out of frustration had committed suicide by hanging by bolting the door from inside. Bolting the door from inside. She was subsequently attempted to be rescued, unsuccessfully. Petitioner is in custody since 27/12/2023. Regarding head to the nature of allegation and period of custody, the petition is granted bail. Yes. Next.
32. Obliged, Lord.
Please, your Lords.
Petitioner custody since 10/1/2022, my lord.
10/1/2022,
my lord. For the alleged offence under section 302, my lord. My lord, it is on the date of occurrence, my lord, there is quarrel between husband and wife, my lord.
Yes, ma'am.
Husband and wife, my lord, quarrel. And in between, my lord, father interfere, and due to sudden provocation, the present person assaulted by means of stick in the head.
To the father.
Father.
He is the son.
He is the son.
Son killed the
Assaulted.
father.
My lord.
Yes.
And my lord, wooden plank was seized from the present petitioner. And eyewitness is the mother, nephew, and also wife of the present petitioner. They are the eyewitnesses. They have stated that the present petitioner has given.
You were drunk. You were drunk.
There
You
is
completely drunk, huh?
Yes, ma'am.
case some action.
Single blow.
Case in the head injury.
My lord, the injury report only due to brain injury. So he has assaulted. But my lord, son has assaulted his father. So
308 not intention is not there, my lord. There is a dispute between husband and wife, my lord.
It's not a premeditated.
Yes, yes.
no, not premeditated.
It's a case of a single blow
To the father.
in the spur of a moment, out of in the fit of rage.
Yesterday, my lord, that the father killed the son. It is all family dispute.
And custody since 10/1/2022.
What was the reason of quarrel?
that is
Begging
the first-
500. 500 500 ଟଙ୍କା ପାଇଁ ପାଟିତୁଣ୍ଡ ହଉଥିଲା।
That was his Swami Sri ଭିତରେ।
ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭିତରେ
This petitioner was quarreling with his wife, and the father of the petitioner intervened. And that time, out of in the fit of rage, he given a single blow
To the head.
died.
Right.
Then that will probably right on. Petitioner is accusing social case and allegation of petitioner. The statement of the witnesses, eyewitnesses, eyewitnesses, recorded by the police under section 161 CRPC was read out extensively in the court, which reveals that the petitioner was quarreling with his wife. At that point in time, his father intervened out of the spur of a moment, out of on the fit of rage. The petitioner appears to have given a blow by wooden plank.
Wooden plank.
Blow by wooden plank on the head of the petitioner, or the head of his father, head of his father, who succumbed to the injury. Petitioner, he was drunk. He was completely drunk to what?
Completely
Drunk.
Intoxicated.
Intoxicated.
Intoxication part, my lord, is not there.
It's not there.
No, my
He's not inebriated.
No, my lord. ମାଗୁଥିଲା ମଦ ପିଇବା ପାଇଁ ମାଗୁଥିଲା କିନ୍ତୁ ସେତେବେଳେ ସେ intoxicated ଥିଲା କି ନାହିଁ।
Petitioner is in custody since 10/1/2022. This is the case where the son has assaulted the father out of on a fit of rage. This is not a case of a premeditated murder. Premeditated murder. At the spur of moment, the incident has taken place, and the petitioner has given on a single blow on the head of the petitioner, head of his father, who succumbed to the injury. Regarding head to the nature of accusation and period of custody for the petitioner since what is the 10/1/2023?
10 custody period.
About 3 years. About
Yes.
3 years.
10/1/20.
2 years. 2.5 years.
2 and years.
Period of custody for about more than 2.5 years. I'm inclined to enlarge the petition on bail. with all conditions. Okay. Yes. 33.
May I please, Your Lordship? And the petitioner has been languishing in the jail custody since 14th March 2024.
Sorry.
14th March 2024, for
14
more than 6 months, madam.
14/3/20.
March.
14th March 2024, for alleged commission of offence punishable under section 379, 425 IPC, madam. Initially, the case was registered under section 379, being charged sheet, my lord, 420 has been added. My lord, it is alleged in the body of the FIR that while the informant was proceeding for Chandavali in a taxi, my lord,
Antecedents.
My lord, 3 antecedents. That the informant is a foreigner man. He is a present petitioner is a driver. He has total stolen 3 lakhs more 3 lakhs.
the driver, my lord, the petitioner is the owner, kindly see, my lord.
No, you were there with the driver of the car.
My lord, I am the owner of the vehicle which is alleged to be utilized in the alleged incident.
Against allegations are against driver. He's the owner. You are not there.
My lord,
1 minute. No, yes, read.
I'm reading that the informant statement. I was stayed at a taxi driver Sagar Malik house with his family members. After 2 days, he came to Puri to the house of taxi driver at Harchandi Sai, Puri. I put my suitcase containing 3,50,000 Indian rupees, wristwatch, diamond ring, and some Canon camera in the taxi driver's house and went to Chandavali with cash of rupees 3,50,000. The said, and on the way, the said taxi driver, means of the present petition, is the taxi driver, come on, drove out from his taxi, fled away. And this present petitioner drove out and fled away. And 30,000 wristwatch and dress, it was recovered from the present petitioner.
Out of 3 lakhs.
Out of 3,50,000. 30,000 was
30,000.
recovered.
Diamond ring.
The wristwatch, dress, it was
Diamond ring. Not recovered.
diamond ring was not recovered. And he
Wristwatch
has also
recovered.
similar
Wristwatch recovered.
wristwatch recovered. Wristwatch, dress, notes, medicine.
Major part you have taken.
30,000. And he has also 3 numbers of antecedents of similar nature.
The problem. Custody only, not even.
My lord,
4-3.
13 days after the incident, FIR has been lodged, my lord. But the petitioner is the owner of the vehicle.
See, the informant is a foreigner. He came to visit Orissa. And he was carrying 3 lakh rupees, diamond ring, wristwatch. He trusted you. He was in your.
I may be permitted to read the statement of one Daniel Knight. I'm just reading, my lord, with permission of my lordship.
Yes,
ମୁଁ ଆଜି 29/2/2024 ରେ ଆପଣଙ୍କ ନିକଟରେ ଦେଇଥିବା ମୋର ମୌଖିକ
read the relevant part. Don't read full.
small section. My lord, 9 ତାରିଖରେ ନେଦରଲ୍ୟାଣ୍ଡ ଆନ୍ଥୋନି ଭ୍ୟାନ୍ ଅର୍କେଲ ପୁରୀରେ ପହଞ୍ଚି ପୁରୀ କୋଣାର୍କ ବେଳାଭୂମି ପାର୍ଶ୍ୱ ପେଣ୍ଠକଟା ମାରାଇନ ଥାନା ଅଧୀନ ତୋଷାଳି ସାଣ୍ଡ ହୋଟେଲରେ ରହିଥିଲେ। ସେଠାରୁ ଏକ ଟ୍ୟାକ୍ସି ଭଡ଼ା କରିଥିଲେ। କାର ଚାଳକ ଟାଉନ ଥାନା ହରଚଣ୍ଡୀ ସାହିରେ ଘରେ ନେଇ ରଖିଥିଲେ। ଡ୍ରାଇଭର ତାଙ୍କୁ ନେଇ ଚାନ୍ଦବାଲି ଯାଇଥିଲେ। ସେଠାରେ ଟଏଲେଟ ଯାଇଥିବା ସମୟରେ କାର ଚାଳକ ତାଙ୍କ ପାଖରେ ଥିବା 3,50,000 ଟଙ୍କା, ହାତ ଘଣ୍ଟା, ମୁଦି, କ୍ୟାମେରା ଆଦି ନେଇ ଯାଇଥିଲେ। ସେଠାରୁ ଛୁଁ ମାରିଥିଲେ। But the present petitioner is the owner of the vehicle.
Owner come drive.
But on the day of alleged incident, the vehicle was being driven by the driver, my lord. As the police, my lord, could not be able to find out the driver, my lord. So therefore, this innocent petitioner has been imputed.
How the recovery was made?
The owner come driver. Yes.
And how the recovery was made?
The recovery from you and.
ସେ ଗୋଟେ ଭଡା ଘର ରଖିଥିଲା। ସେ ଟ୍ୟାକ୍ସି ଡ୍ରାଇଭର ଗୋଟେ ଭଡା ଘର ଥିଲା।
Anyway, wait for another few months. At least it in the November end. November end, I'll give you bail. Wait for some time. Had it been an Indian, I could have granted bail. He is a foreigner.
This is no way connected, man.
You are.
The incident took place, but
When the charge sheet filed, item
33.
33, yes. Charge sheet, when the charge sheet filed?
Charge sheet submitted on
12/5/2024 में। Offenses are tribal to magistrate by
Tribal magistrate is all right.
staying is custody for more than.
You repeat the bail plea there and high trial court. You should suffer a little bit because you have cheated foreigner. The confidence of the tourist,
a wrong message will go.
That's the reason. Otherwise these
country lose huge amount of foreign currencies.
See, diamond ring and all. Petitioner seeks to withdraw the petition to renew his bail plea before the trial court in view of the changed circumstances. change circumstances, liberty granted to the petitioner to renew his bail plea before the trial court on the trial court. If such bail application is not, same shall be considered on the basis of the material form part of the charge sheet, form part of the charge sheet. With this observation, the petition is disposed of. Yes. Next. 34.
May I please, my lord? The petition is considered, my lord, 14 March 2024, my lord. My lord, initially 14th March 2024.
Yes.
Well, initially the FIR was lodged under section 365 and 34 IPC. It's a case, my lord, interestingly, that one Bapi Naik and Debjani Naik came to the informant's house.
What are the offenses?
Offenses now, my lord, that is 365, 366, 370.
When the charge sheet filed?
My lord, as per my information, is 3-4 days back it has been filed.
You renew your bail.
Interesting part, my lord, what has happened, my lord, I have married it.
The most interesting part is
Moment
you have not
trafficking
filed
lordship.
anything.
My lord,
Most interesting part is you have not filed anything except rejection order.
actually,
I have been searching.
the charge sheet has been filed. As per my information, charge sheet has been filed. Lord, sir, can it put it to next week so that I can file it?
Now charge sheet has been filed. What are the offenses in charge sheet?
On charge sheet, I have got the information that 365, 366, 370, 370.
You renew your bail plea because your bail plea was rejected much prior. When
Much
the
prior,
investigation was going on. I'll give 15 days to decide the trial court. I'll give direction that the trial court should
Or
decide
otherwise,
your
Lordship
bail
may permit me, my lord, I will file the charge sheet here also. Lordship.
No, you have not filed the FIR. What to talk about?
At that time, it was not filed. 2 days, 3 days back, it has been filed. So,
The petitioner is agreed by the order dated 22. In fact, I am rejecting all the bail application where nothing is filed.
Okay.
So I'm not rejecting. I'm just giving you. Right.
Otherwise, I will pay my lord. I will withdraw the petition, my lord. Can withdraw it.
Petitioner is agreed by the order dated 22/4/2024, whereby his bail plea has been rejected. His bail plea was rejected during the period of investigation. Subsequent thereto, charge sheet has been filed. Therefore, the petitioner, counsel for the petitioner seeks to renew his bail plea before the trial court and the changing circumstances. If such application is filed, the same shall be considered on the basis of the material form part of the record within 15 days from the date of moving such application. With this liberty, the petitioner is disposed of.
Obliged.
My lord, the petitioner is in custody from 2nd April 2024. The offense.
2nd April?
Yes, ma'am. Offense alleged against the petitioner is 420 and 408 and charge sheeted under also same offense.
Yes.
The allegation is he has misappropriated 45 lakhs of gold ornaments and 35 3,55,000 cash from the showroom.
Showroom?
Yes. Informant's lawyer.
Well, showroom
He was working as a manager. He was employee in the showroom of a tarnished showroom. So he has misappropriated. That is the allegation. And I'm in custody since 2nd April. The informant has also appeared.
What do you say?
So it has been settled amicably and
yes, they have compromised.
If they will compromise, I have nothing to say. Let's see. Otherwise, seizure is there, everything is there.
But the next people are here. What to do? They're happy with this kind of employee.
Yes, sir.
he has lost his job.
You don't need to work. If you earn so much, why should you work? Better way, you.
ଯାହା ନେଇଥିଲା ତାକୁ ତ ଦେଲା ଯାହା ବି ଫ୍ୟୁଚରରେ ପାଇଥାନ୍ତା ସେ ବି ହରେଇ ଦେଲା.
Where is your wakalat now? File. Petitioner is accused in so case. Notice was issued or so moto you appeared?
No, he has appeared so moto because in the meantime everything has been sorted out, so he has appeared.
But see, the problem is he has filed wakalat now. For whom?
Informant.
Where is that? He is not a party to this.
No, he is not a party. In this application, he need not be a party. But informant, he can assist your lordship.
I have believe it, whatever it is. Though the informant is not formally included in this petition, however, so had what is the name? Sorry, sir, I don't know the name. Where is your wakalat now? Yes. Mr. Niranjan Maharana and Amitabh Mahapatra. Niranjan Maharana, Amitabh Mahapatra, and Arun Kumar Sahu entered appearance on behalf of the informant. On behalf of the informant. The Mr. Bose, learned counsel for the petitioner, submits that the petitioner was working in as a working as manager in the Tanix showroom, where it is alleged that he has misappropriated Tanix
Gold ornaments of 45 lakh 67,000, 45 lakh 67,000 and 3 lakh 55,000 cash shortage was there.
The counsels appearing for the informant submit that they have settled the issue and satisfactorily recovered the amount of the accused. The accused has been in custody since 2/4/2024. Regarding to the fact that the informant has checked that the parties have settled that issue and the informant entered appearance in the present proceeding and stated through the counsel that they have recovered the amount, and the fact that the petitioner is in custody since 2/4/2024, I am inclined to enlarge the petition on bail accordingly granted. Yes.
Grateful, man.
Yes.
36.
36.
Offense under section
madam.
302-498 IPC, my lord.
TD has come.
Yes, sir.
Yes.
We moved before charge sheet, my lord. Liberty may given to move after charge sheet.
Sorry, I didn't follow you, ma'am.
Recently charge sheet filed, my lord. We moved
Before
before charge sheet.
Rejection at the time charge sheet.
The petitioner is agreed by the order dated 18/4/2024, whereby his bail plea has been rejected by the court below. Subsequent thereto, charge sheet has been filed. In the changing counsel for the petitioner seeks to renew the bail plea before the trial court on the changing circumstances. Therefore, the liberty is granted to the petitioner to withdraw the petition to renew his bail plea before the trial court. That is this portion. Yes.
Next, last occasion, my lord, I filed the petition for addition of victim girl. Already have filed.
Addition for?
Victim girl as party.
Yes.
Already have made party. And
Yes.
friend has appeared on behalf of the, already matter has been complied. Petition is custody since 8/5/24.
8/5/24.
24. And already she has given statement before the court that there is a compromise and we have no.
What are the offenses?
Offense 376 POCSO is there. And the parties are also there. The victim girl is also present in the court. The order date has been 18/8/19 na. Set order ta last day before yesterday it was listed. My lord, wrongly it has been instead of 18 it has been 18/8 instead of 18/9.
But you have implemented.
I have implemented.
Have you implemented the informant and he is appearing, he says that he has no objection and the parties are also present. Grant bail that petitioner is taking don't go. Allegation persons to which are the wherever I said that you have to implead.
My lord, I is there. I have filed this. I application.
Take them out. They are not required. They are not required. Let them go. No problem. Yes.
I application is there, my lord.
IA you filed?
Yes, ma'am.
That was allowed.
Today it has been there. The day before yesterday, my lord was directed.
Okay.
And
the petitioner have filed an IA seeking to implead the informant in the present case.
Victim girl.
Victim in the informant case.
Doctor.
IA number 1225. ऊपर सबूत लिखो. The application is allowed. Application is allowed. Further stated in the application. So you have filed वकालतनामा, sir?
Yes, my lord. My lord,
no?
he has also filed vocal.
So
Vocal,
and
they
so
have
has
the record.
entered appearance for the victim, entered appearance for the victim and filed the for next one, main matter. The petition is issued on so and so case and allegation of the petition so on. The victim is also present in the court today, being represented by the her counsel and identified by him. The victim has no objection if the petitioner is granted bail. Regard being had to the period of custody of the petitioner from 8/5/2024 and the fact that the victim herself is present in the court and making a statement that she doesn't have any objection if the petitioner is granted bail. I'm inclined to enlarge the petitioner on bail if it is granted. Yes. 38.
May I please, Your Lordship? I'm in VC, my lord.
Yes, yes.
I'm in VC. In this case, in connected matter, Your Lordship granted bail to the co-accused person, item 44, yesterday list, my lord. That is similar to this case, my lord. Receiver of
18 antecedent is there, Lordship.
that is there in
board ornament is
44.
recovered, Lordship.
That is item 44, yesterday list. That is same thing, my lord. Receiver of stolen property and he is inside the custody basing upon the contestant statement.
How many
Yes.
antecedent that gentleman had?
18 cases receiver of stolen property. In item 44 also same, yesterday list, my lord.
Is it so?
Yesterday list 44, I don't know.
Yesterday that the
Here is-
ornament which was stolen from the mandir, various temples.
Mandir, that is.
He is same person.
Same person, man. Akhtar, he's another co-accused person. That was
Another co-accused, another. Same case, same thing.
Sirauddin was the present petitioner yesterday. Now the Akhtar, from the same affair.
Okay. Tuesday, listed on Tuesday. Tuesday.
Along with my lord, item 44 yesterday list, my lord.
See, the problem here, one more problem is the another matter 5924. This is same affair.
Same affair.
No, it is 88, that is the 9. That is, Lordship, Kamarda PS case number 9. This one, Jaleswar PS case number 88, second one.
Same in item 44, one person, 3 cases have been filed. Item 44 yesterday list, my lord.
1 minute, sir. The problem is the coordinate bench has heard one of the matter. That is Akhtar Khan is na? Is Akhtar Khan. 8188. In the same FIR, co-accused bail has been dealt with by the coordinate bench. So it has to go to that bench.
Right.
That has to go.
As your lordship.
Sub-item. Now, what about the first item? First item we can hear. But in so far as the sub-item is concerned, it has to go to.
Your lordship, I will send it to the concern.
Then both the matters. Yes.
First item has been disposed of, my lord.
First item Tuesday and the second item I am sending it to coordinator.
My lord.
Yes.
ସେଇଥିରେ ସେ ସବୁ ମିଶି ଦେଇଛି ସେଥିରେ ସବୁ ପୋଲିସ ଷ୍ଟେସନର କାଗଜ ଗୁଡାକ ମିଶି ଦେଇଛି ଜଣ ଯାହା ରିକଭର ହେଇଛି ସିଡି 597 ଲେଖା
may be Lord, my lord. It's a case under the section 307, my lord.
Yes.
Along with other offences, my lord. The petitioner is in custody since 5/2/2024. Meantime, my lord, since 19/4/2024, charge sheet has been submitted, my lord. And the petitioner is the first offender, my lord. My lord, it's a sudden provocation, my lord. Here allegation that 3 persons assaulted 1 person, my lord.
Yes. Yes, sir.
Let's see where is there. Let's see, I am reading the 164 statement, Lordship.
Yes.
ଗତ ଫେବୃଆରୀ 24 ଶ୍ରୀପଞ୍ଚମୀ ଦିନ ବ୍ରଜବନ୍ଧୁ ସ୍ୱାଇଁ ତାଙ୍କ ପୁଅ ବାପି ସ୍ୱାଇଁଙ୍କର ତଳଗଡ଼ ଗଡ଼ିଝିଆରୀ ସ୍ୱପ୍ନେଶ୍ୱର ମନ୍ଦିରର ରିଙ୍ଗ ସେରିମନି ହେଉଥିଲା। ଆମେ 6 ଭାଇ ଓ ସୁଶାନ୍ତ ରଣା ସେଇ ଠାରେ ଶୈରନ ମନ୍ଦିରରେ ଥିଲୁ ଭୋଜି ଖାଇବାକୁ ଯାଇଥିଲୁ ଆମ ଗାଁର 10-11 ଜଣ
ଏଇଟା ମୋ
the
case.
name is here in the petition is there huh
Case number 5952.
5952 5952 same here 5952 let's
5952.
My lord, next sir 4 is the statement of the victim, my lord. Running page 26. Running page 26, my lord. I am placing my lord.
Read it out. Read it out.
May I read my?
Yes, yes.
ମୋ ନାମ ପପୁନ ଜେନା।
Read the relevant part. Don't
Yes,
read.
sorry my lord। ଏତିକି ଯେ ଗତ 1-2-2024 ରାତି ପ୍ରାୟ 2ଟା ପାଖାପାଖି ହେବ ଖାଇସାରିଲା ପରେ ମୁଁ ରାସ୍ତାକୁ ଯାଇ ଛିଡା ହୋଇଥିଲି। ଠିକ ସେତିକି ବେଳେ 3 ଜଣ ଯୁବକ ନିଶାସକ୍ତ ଅବସ୍ଥାରେ ଏଇ ରାସ୍ତାରେ ଆସୁଥିବା ଦେଖି ମୁଁ କିଏ ପଚାରିଲି। ଏତିକି ବେଳେ ସେମାନେ ସୁଆନସୋ ପଚାରିବାରୁ ମୁଁ ତାକୁ ସୁଆନସୋ କହୁଛୁ କହିବାରୁ ସେ ମୁଁ ଆମ ଭିତରେ ଯୁକ୍ତିତର୍କ ଲାଗିଲା। ଯୁକ୍ତିତର୍କ ଅଧିକ ହେବାରୁ ଆମ ଭିତରେ ଜୋରେ ପାଟିତୁଣ୍ଡ ହେଲା। ମୁଁ ରାଗି ଯାଇ ଅଭିକୁ ଗୋଟେ ଚଟକଣା ମାରିଲି। ତାପରେ ସେମାନେ 3 ଜଣ ଅଭି ଗଣେଶ ରାଜା ମିଶି ମତେ ତଳେ ପକେଇ ନିର୍ଦ୍ଧୁମ ବାଡେଇଲେ। ଯେତେ କହିଲେ ବି ମତେ ପିଟ ନାହିଁ, ମୁଁ ମରିଯିବି। ସେମାନେ ମତେ ମୋ କଥା ନ ଶୁଣି ମତେ ପିଟା ପିଟି ରକ୍ତାକ୍ତ କରିଦେଲେ। ଏତିକିରେ ତାଙ୍କର ରାଗ ଶାନ୍ତ ହେଲା ନାହିଁ। ସେମାନେ ରାସ୍ତାରେ ପଡିଥିବା କଂକ୍ରିଟ ପଥରରେ ମୋ ମୁଣ୍ଡକୁ ବାଡେଇ ଦେବାରୁ ମୁଁ ଚେତାଶୂନ୍ୟ ହୋଇଗଲି।
You show me the medical evidence.
Medical, my lord, medical.
You are Ganesh.
Yes, my lord.
You are Ganesh. Yes. Show me the medical evidence.
My lord, running page 25, my lord.
25.
My lord, second paragraph, my lord. During investigation, IO visited the spot, examined the informant and other witnesses and recorded their statement. The injured Papun Kumar Jena was examined medically and injured report was shows that sustained one bruise of size.
So head injury.
Yes, my lord.
So bleeding injury. So all the injuries are grievous in nature. On basis of the health status of the report, it is noted that some part of the injured are also not functioning properly.
Yes, my lord. And it's a case of
And the injured
February, month of
is in the
February.
wheelchair and could not walk without taking the help of others.
My lord, it's a case of
Treated so brutally, he is become wheelchair bound.
Yes, my lord. It's a sudden provocation, my lord. Not
Implicate the injured and take the bail. Implicate the.
My lord, since
Land counsel for the petition.
February, it's a case of.
It's all right.
I mean, the charge sheet.
I just want to know about the injured's health.
And last occasion that order was passed to take instruction regarding the health condition of the.
There is no instruction.
that is not come lordship injury report also is that
Injury report I have seen it.
Yes.
He is wheelchair bound now.
Yes.
You tell me what is the status?
That is the rejection.
That I will ask.
That is the rejection of 25/4/2024.
Right. The petitioner is one of the accused among other.
Because from SCB he is
there are 3 accused. How many accused? 3
accused, man.
Shifted to Institute of the Medical Science.
The allegation against the petitioner is that they have he along with 2 others were coming where had assaulted the injured on the slight pretext on the slight on the slight provocation. And the injuries the victim has received many injury as a result of which was hospitalized and subsequently he become wheelchair bound. Since the nature of injury attributed to the acute persons are serious in nature, the State Council is directed to seek instruction regarding the health status of the injured. Lease the matter after 2 years. And it is made clear that no further adjournment shall be granted to the State Council on any pretext.
Free copy of order lordship.
You get the state status of health status of
Again he is transport to SCB to Utkal Medical lordship.
Yes, now health status because that time he was wheelchair bound.
Yes.
The order was passed long back. By now he might have recovered also. If he recovered, then he's entitled to be. Yes. I'll just.
File ଏବେ କେମିତି ଆସିଲା ଏଟା? What was it? File ଟା ତ ନଥିଲା ଆସିଲା କୋଉଠୁ?
Entry matter is there.
Entry matter is there.
So wait.
To be continued, my lord.
You are for petitioner.
I am for the petitioner.
Who is for the other side?
Other side is not there. Last time he was there.
Let him come.
If it will be taken up, like my lord, I am ready.
1 minute. Let it come.
My lord.
Yes. Yes.
My lord.
498. Yeah.
My lord.
Yes.
Petition number 1, husband.
Okay.
2 is my lord, sister-in-law, and my lord,
And
mother-in-law.
Ranjit.
Ranjit, my lord. Ranjit, my pradhan.
Jameshwar.
Jameshwar.
Arundhati. Anupama. What is the terms of settlement?
But my lord, they are residing. My lord.
Okay. At the instance of opening party number 2, FIR number 2, allegation against petitioner number 1 is the husband of the opposite party. The dispute is essentially arising out of a matrimonial dispute. The parties have settled their dispute, and the petitioner, opposite party number 2 has started. The opposite party number 2 has resumed his marital life and started staying with the petitioner. The petitioners and opposite party number 2 are present in the court, being represented by the respective counsel and identified by them. They have also filed their self-petition copies of the Aadhaar card to establish their identity, which are taken on record. The parties have also filed a joint affidavit dated 29/1/2024 inter alia, stating that due to misunderstanding, the FIR was registered, and now they resume their marital life. Hence, the opposite party number 2 is not interested to prosecute the petitioner anymore. Regard being head to the nature of Mr. Arora submits that this being a matrimonial discord, and the parties have settled the dispute. There is no legal, no legal committee and so on so, and therefore, they are covered by the judgment of the Honorable Supreme Court in BSUC. Regard being head to the aforementioned, and in view of the judgment of Jan Singh and BSUC, subjecting the petitioner to trial would be a futile exercise. Therefore, the petition deserves merit. Accordingly, the proceedings are passed. Yes.
Petitioner 1 and opposition 2 filed their affidavit.
Now, parties have filed this to petitioner 1 and opposite parties. Yes. Bail.
Item 40. The petitioner inside the jail custody since 16/2/24, my lord. Charge sheet submitted on 13/6/24 for commission offence 144, 145, 48, 223, 302, 294, 506, 149.
Custody since
16/2/24.
Yes.
Kindly glance to page 8 written FIR.
CD is there?
Yes.
CD is there. Yes.
And there is written FIR, my lord.
This is my appeal to inform, my lord. Trial has already started, my lord. And eyewitness is already examined, my lord.
Show me eyewitness. Examine. When? Eyewitness.
Already examined, my lord.
Huh?
Three eyewitness.
You tell me the dates.
Dates and nothing.
My lord, 10th रे तीन police तीन जन examine ହେଇଛନ୍ତି 10th September.
Eyewitness. He
No,
says
madam.
eyewitness examine.
Yes, eyewitness.
One is eyewitness.
Nityananda Rana.
Nityananda Rana. Examine.
Yes, no.
When he was examined?
10/9/2024. Cross examine not cross examine deferred.
Petitioner is agreed by the order dated 18/2024, whereby bail has been rejected. Subsequent thereto, the evidence of the eyewitness and other witnesses have already been examined.
Cross examination है.
Cross examination है नहीं मेरा. Only
however, they have not yet been cross examined. In view of the changing circumstances, petitioner should renew the bail plea before the trial court. After the cross examination of the witnesses, those who have already been examined is carried out. If such bail application is moved, same shall be considered on the basis of the material available on record. Then, yes, next. 41. Yes.
My lord, the petitioner is in custody since 14/2/2024 for the alleged offence under section 323, 363, 376.
Notice has gone, but
372A.
no return has come. Notice has gone, Lordship, but there is no return of
Notice service.
At best, a case of 498A.
When the notice was issued?
Plain reading of the
notice was issued. When was the notice issued?
No notice issued, but directed, I think.
We have given a notice to the victim, but that is, there is no return of the tool.
Judicial order.
Court has not issued notice.
No, no, madam.
Court
If Lordship kindly go.
Court has given direction.
See, one.
No, where is the order?
No, no judicial order is there.
Yes.
Let's see the 376.
Case diary is there?
No, case
Okay. Case diary direction is there. Pursuant to the order dated to
Yes, short date,
case diary has not yet been received by the council for the state since he handed his 6 time of 2 weeks. Reach the matter after 2 weeks.
42 offense under section 307. The petitioner is in custody since 15th of March 2024. Subject to verification of a non-friend, but my instruction that the injury which was caused simple in nature. Already
Yes.
6 months,
Injury.
5 days inside custody.
12 injuries, Lordship, there. 12 multiple injuries are there. And seizure is there. Sword and cutting.
Sword.
Yes.
Sword. And any previous injury? Which
Previous not that that injury only. Though they are simple in nature, but 12 in nature in multiple injuries in head, neck, and other parts also. Vital parts.
What has he used?
Allegation that specific, they have stated that the FIR allegation that they used to conduct Kati and assaulted. This entire occurrence took place due to they have got the previous enmity since long.
Sword and Kati.
Yes, sir.
Okay. Let the witness be examined. When the charge sheet was filed?
Charge sheet date
I'm saying this.
But I moved the bail application when the investigation was in progress.
Charge
sheet 13/7/24.
Right. Petition is agreed by the order dated 28/5/2024 passed by the trial court, whereby his bail plea has been rejected during the course of investigation. Subsequent thereto on charge sheet
13/7/24.
13/7/2024 charge sheet has been filed. In the changing circumstances, petitioner seeks to renew the bail plea before the trial court. If such bail plea is moved, same shall be considered on the basis of the material form part of the charge sheet. Yes.
48 also another accused.
48 of same one. 43.
Yeah. My lord, 302 along with other offences is there, my lord. Here, my lord. Yes.
Yes.
My lord, petitioner is bonda by caste, my lord. He used to bonda by caste, my lord. And he used to drink, my lord. And on the relevant date, my lord, he had gone to the neighbor's house for some liquor, my lord, countryman liquor. While he was denied, it was denied. Suddenly, he given a my lord blow. Thereafter, this
blow.
Yes, my lord.
Blow and neck, that ornament is there that ladies are wearing. That stretch it and she died.
My lord,
eyewitness there.
Yes.
My lord, even my lord.
Custody since?
Custody since, my lord, 9/5/2023, my lord. Till date, my lord, charge are framed. No witnesses have been examined.
Yes. How many witnesses are there?
That I am saying.
My lord, 18.
18?
Yes, my lord.
Eyewitness?
No, my lord. 18 witnesses are there.
Eyewitness I am talking about.
My lord, given a fist blow only, my lord.
Not fist.
I am talking about
yes,
eyewitness.
Yes, my lord.
Three or dealers.
Huh?
Or
not you know. Petition is accused in so allegation is petition so. There are eyewitness to the occurrence. I have queried the statement of the eyewitnesses recorded under section 161. I'm not inclined to enlarge the petition.
No weapon has been used.
However,
No, Khogla.
however, liberty is granted to the petitioner to renew bail after the eyewitnesses are examined. Trial court is directed to do well to see that the eyewitnesses are examined preferentially over all other witnesses. Yes.
44.
44, my lord, prepare 1 week after, my lord. In the meantime, my lord, file requisite, my lord.
Sorry, I didn't follow you.
My lord, 1 week after.
Yeah.
My lord, in the meantime, requisite file, my lord. 376(3) is there, my lord.
Requisites have not been filed.
Earlier, my lord.
What is the defeat to opposite party, the informant of the injured, informant of the victim? However, requisites have not filed. Then counsel for the seeks to file requisite within 1 week, means the matter after 4 weeks.
Oblige, my lord.
November last week.
45.
May I please?
Yes.
My lord, I have filed one IA, that is 816 of 24. May I be permitted to withdraw that IA?
IA?
IA.
Then counsel for the
816 of 2024.
withdraw the 816.
My lord.
Withdraw the IA number 816 of 2024.
My lord. But here,
Yes.
here the present petitioner, my lord, is the mother-in-law, my lord. PM report I have annexed. Lordship may PM report and all the relevant document I have annexed under Annexure 2 series. Lordship may kindly see page 35, my lord.
Yes.
The cause of death is due to asphyxia resulting from antemortem hanging, which is suicidal in nature.
Yes.
And
custody,
the present petitioner voluntarily surrender before the learned court below. The present petitioner along with
custody
since 11/6/2024.
11/6/24.
Again.
Only.
If you 60 years old lady, my lord.
So that's 16, my lord. And in fact, on the date of occurrence, petitioner not there. There are the house, my lord. Here are the Assam, my lord. Substance acid submitted showing all the accused person are surrender. They all surrender in the
Sosuro Sasu, semana ସବୁ Assam.
16 case.
Sosuro Sasu, present
right, on merit you don't speak. Merit you have a case.
Yes.
But how will you explain the
my lord,
part?
that is I'm explaining, my lord. My lord, since last 20 years, my lord, the husband of the present petitioner, the father-in-law, he is working in Assam. So the present petitioner is with her husband at Assam. The incident took place in my lord, here, my lord. The dispute between his her son and
where is your application for while surrendering? Have you said all these things?
My lord,
have you said all these things anywhere?
That I have voluntarily surrendered before the learned court below, my lord.
No, you have explained why, wherever you. Or you now cooking up a story.
No, my lord. That is the fact, my lord.
So many
that is the fact.
On record that
yes,
you are not there in Assam, whatever.
This petitioner and her daughter, my lord, both have surrendered since daughter religion bail only because he is having small kids with her. And this petitioner, my lord, is 60 years old.
That's right, but here, show me something that you were in Assam, you couldn't do.
Aଜ୍ଞା ମୋ ଚାର୍ଜ ସିଟ୍ ରେ ବି ଲେଖା ହେଇଛି ଆଉ ଷ୍ଟେଟମେଣ୍ଟ ଗୋଟେ ବି ଆଜ୍ଞା ପଢି ଦଉଛି ଦ ଷ୍ଟେଟମେଣ୍ଟ ଅଫ କମ୍ପ୍ଲେନାଣ୍ଟ ଅନନ୍ତ ଚରଣ ବଳ that is at page 33 lordship may kindly peruse ବିବାହ ପରେ ମୋ ଝିଅ ତାର ଶାଶୁ ଘରେ ଭଲରେ ଚଳୁଥିଲା ଜ୍ୱାଇଁ ଅସୀମ ମହାନ୍ତି ଓ ତାଙ୍କ ଶ୍ୱଶୁର ଅଙ୍ଗନ ମହାନ୍ତି ଆସାମରେ ରହି କାମ କରନ୍ତି ଘରେ ତାର ଆଈ ଶାଶୁ ସହିତ ମୋର ଝିଅ ତାର ଛୋଟ ପୁଅକୁ ଧରି ରହୁଥିଲା ତେଣୁ ଘରେ ଆଉ କେହି ନଥିଲେ ବିବାହ ପରଠାରୁ ତାର ସ୍ୱାମୀ ଶାଶୁ ଆଈ ଶାଶୁ ଶ୍ୱଶୁର ନଣନ୍ଦ
okay don't be make me more wiser I understood it
well
they must be in the Assam and in these kind of cases why police will tell them right now petition the accused and so Although the charge sheet was filed on
Charge sheet was filed on 21/3/2020.
21/3/2020. However, the present petitioner was present. All the accused persons were shown as absconder. The how many accused persons? 3.
My lord,
No, my lord.
accused persons are, my lord, 4.
4. All the accused persons were shown absconder. The present petitioner, who is the mother-in-law of the deceased, has surrendered before the court on 11/6/2024 and continuing in the custody. From the perusal of the evidence form part of the charge sheet, it reveals that on the date of the commission of suicide by the wife of by the daughter-in-law of the petitioner, the petitioner was not even present in the spot. It has come on record through the evidence of through the statement of the witnesses that in fact the petitioner is staying at Assam, in Assam, along with her husband. Mr. Mishra and counsel for the petitioner submits that since the present petitioner was staying in Assam and he had no clue regarding the filing of the charge sheet, and the police has never attempted to arrest the present petitioner, rather chosen regard being had to the nature of acquisition and the period of custody and the age of the petitioner. I'm inclined to enlarge the petition on bail according to the
One thing, my lord. In place of 4 accused, there are 5 accused.
5 accused. And Mr. Mishra further submits that one of the co-accused
has been granted bail by the learned court.
One of the co-accused, who is the sister-in-law of the deceased, was also shown to be absconding, and when she surrendered before the court, she was immediately
granted bail.
Enlarged on bail.
Since she is having
breastfeeding child.
Enlarged on bail. Yes.
May I please?
46. Yes.
I'm appearing to the informant.
Yes.
Lordship, the alleged offences are 417, 323, 376.
Custody, you tell me the custody.
Custody since 12th May 2024. In last occasion, your lordship were directed to obtain that 164 statement of the other. They were, as per the allegation of here, FIR, your lordship, they were in relationship, love and relationship since last 2 years. They went together 2 years. And se taku janila Instagram ru janila taku.
164, read 164.
My lord, he has filed the application, my lord, before submission of charge sheet.
No, what is your age?
Yes, my lord, 22.
You are age 22.
My age 22.
You are age 26. Okay, read 164.
But before
Right, not in every case. If I don't want to give bail, then only I find out the way to send you out.
No, my lord.
If I want to give bail, I give here only.
If a lordship that, my lord, before going to that, my lord, I am submitting. My lord, he has granted.
You are in consensual relationship or not?
My lord,
yes,
that is on my lord, threat, my lord. Why I am saying, my lord?
Let us see 164.
Just, my lord.
1 minute, let me read.
ପ୍ରାୟ 2 ବର୍ଷ ହେବ ମଙ୍ଗଳପୁର ଗ୍ରାମର ଲିଟନ ଅଶୋକ ମଲ୍ଲଙ୍କ
while granting bail. Yes.
While granting interim protection, your lordship, your lordship.
You want protection?
No.
I have granted bail. Why unnecessary?
It is a case of elopement, lordship. Out of love relationship, the
Yes, custody.
Constitution 2-3 issued by lord, but somebody appearing by lord for the opposite party, my lord.
In fact, case there 164.
164 is there, lordship, and obtaining the PP copy.
Case there one after 1 week. Case there 48. 49 years.
49. May I please?
Offense under section 341, 294, 323,
Yes.
307.
Custody.
Since 24th April 2024.
Yes.
Charge sheet has submitted and no criminal antecedent.
Offense?
Offense is 307.
Yes, injuries.
49.
Show me the injury.
My lord, in this case, anticipatory bail was granted, but due to the grievous injury to it was rejected.
CD, call for CD. 2 weeks. Yes.
Item 50.
Obliged. Date.
50. Yes. Yes, sir.
50.
Meet features. And it is a peculiar case where the present petitioner is 42 years and the victim is 36 years. And the charge sheet has already been submitted under section 376(2)(n) of the Indian Penal Code on 15/5/2024. And the petitioner is in custody since 21st March 2024.
Okay.
And as it reveals from the contents of the affair, that their relationship developed through social media. And they continued their relationship since the year 2023. And thereafter, it is alleged that after giving promise for marriage and
So read 162.
ଜଣେ ସାଙ୍ଗ ପାଖକୁ ଫୋନ ଆସି ଫୋନ ନମ୍ବର ଆଣି
1 minute. Custody says.
since 21st March 2024.
Yes.
ମୋ ଜଣେ ସାଙ୍ଗ ପାଖରୁ ଫୋନ ନମ୍ବର ଆଣି ସୁକାନ୍ତ କୁମାର ନାୟକ ପିଟିସନର ସହ ମୋର କଥାବାର୍ତ୍ତା ଆରମ୍ଭ କରିଥିଲି। ଏହାପରେ ସେ ମୋ ସହ ବାହାଘର ପ୍ରସ୍ତାବ ଦେଇଥିଲା। ମୋ ଘରକୁ ଯାଇ ପରିବାର ସହ କଥା ହେଉଥିଲା। ଆମେ ବାହାଘର ନଭେମ୍ବର 18କୁ ଠିକ ହୋଇଥିଲା। ଏହାପରେ ଜୁନ 23 ତାରିଖରୁ ମୁଁ ତା ସହ ସିଆରପି ସ୍କୋୟାରରେ ରହି ଆସୁଛି। ଏହା ଭିତରେ ମୁଁ ରହି ଆସୁଛି। ମୁଁ ଥରେ ଶାରୀରିକ ସମ୍ପର୍କ ରଖି ଗର୍ଭବତୀ ହୋଇଥିଲି। ମାତ୍ର ସେ ଅଜାଣତରେ ମୋତେ ଔଷଧ ଦେଇଦେବାରୁ ମୋର ଗର୍ଭପାତ ହେଲା। ସେ ମୋ ଠାରୁ 36 years. But in fact, one thing, my lord, subsequently the victim came to know that the petitioner was a married man.
What is her age?
36.
36. You should know what is the consequence. And what is the age of this man?
42.
I think the first page is missing in the petition.
No, earlier bail application was not moved. This is the first.
Kenny, there is problem in Kenny. Sukant Naik, huh?
My lord.
Notice was issued to.
Notice not permanent. 370 not
370. But he has impleted.
Impleted.
No, petition rejection in delegation during investigation, the statement of the prosecutrix, who is stated to be 36 years, have been recorded by the recorder under section 164 CRP. He in her statement stated that he was in relationship with the present petitioner, who is 42 years of age. In the November 2018, the present petitioner proposed to marry her and approached the family member of the victim. Subsequent thereto, they started residing in Bhubaneswar together. During their stay, the petitioner has sexually exploited the petitioner. Subsequently, the petitioner wriggled out of his promise to get married. Hence the FIR. Petitioner is in custody since 21/3/2024. Regarding it to the nature of acquisition and the period of custody, and the age of the victim and the petitioner, I am inclined to enlarge the petition on bail accordingly. Yes.
Obliged.
51.
Yes. CD 376D. CD. Call for CD. Yes.
52.
Offense under section 376 and 6 of the POCSO Act is also there. For the
376 there, my lord. Notice issued, but could not be served, my lord.
serve the notice to
Notice
opposite,
to be written as
opposite-
answer with the endorsement address cannot be.
opposite party number 2 through the IO of the present case leave the matter after 2 weeks. Yes. 53. 53.
May I please?
Yes.
Person custody since 53. Yes, CD is required.
All for CD.
Nay, one thing, submit one thing, in the meantime, out of 32 witness, 12 examined, a soft copy of the.
You want to repeat?
No, 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 already thereafter, a bail application file below.
Let's see.
ମୁଁ ଖାଲି deposition copy ଟା ଦେଇ ଦଉଛି 1 to 12 let that record maybe.
Okay. 54. 54. Next. 54.
53 Lordship, I have already submitted deposition copy.
See, let the CD come.
Yes.
Yes.
54. 54 also CD mallards
54 CD.
55. 55 also something mal CD.
CD.
164.
55 next week, my lord.
CD call. So
Sorted.
all date will be here.
56.
50 offense under section, my lord. 76 2N, other allied offense. Victim and the petitioner both are 20 years, my lord. And they are loved with each other. And from
164.
Yes, 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 my lord. 164 is there, my lord. And love relationship is there, and the relations, physical relationship is there.
Custody?
Custody 29/5/2024.
5/2024. Okay. They were related.
Yes, my lord.
They were in
Three pages, 164 statement, my lord. The entire
Entire
incidents from the date of starting to till date. Nothing else.
20-year-old boy.
Yeah, both are
20 years. Both are
They
friends.
could marry.
Let
I know. Petitioner is accused in so and so case. Allegation that the petitioner. The statement of the victim who is stated to be 20 years. 20 years. Okay. Was recorded under section 164 CRPC. She in her statement has narrated the entire incident and has entire incident and has stated
accused threatened for virality
and has stated
Only threatened.
that they were she was in relationship with the petitioner who is also 20 years of age. Both of them had a physical relationship on consent on the consent, and the petitioner was had promised to marry the opposite party number 2. However, subsequently wriggled out of his promises. Therefore, he filed the FIR.
Yes.
Petitioner is in custody since 29/5/2024. Regarding head to the nature of the accusation and age of the victim and the petitioner and period of custody, I'm inclined to enlarge the petitioner on bail and referee. Yes.
57.
May I please, Lordship? My lord, on behalf of Mr. Sutar, the petitioner in custody 23/4/24, my lord. Offense under 376 and 417, my lord, IPC. The matter becomes settled and the married victim lady is married and another boy, my lord.
Another boy.
In this case, I am appearing on behalf of the informant, my lord. In the meantime, matter has already been settled. Informant married to another person. She is also filed, your lordship, have a glance, filed affidavit regarding veracity of facts.
Okay. That
Yes.
petitioner is accused in so and so, allegation with the petitioner so and so. The charge sheet has been filed?
Yes.
Huh?
my lord.
Charge sheet filed?
Yes, my lord.
Charge sheet in the after investigation, charge sheet has been filed for alleged offense under section 326.
My lord, that's
417.
Huh?
417.
417 IPC. The petitioner, when the matter stood that, the petitioner, the petitioner and the victim girl has entered into a settlement. Have you filed affidavit?
Yes, my sir.
Where is that?
Last date is filed is
No
on
affidavit
record
is there.
affidavit.
No affidavit is there. Yes, affidavit. To that effect, the petitioner, the opposite party number 2, opposite party has filed an affidavit inter alia stating that she has married with one Mohammed Saleh Mohammed Salman, of Barbil, this is Kyonjar, and dependency of the present case may jeopardize his marital life. Therefore, she doesn't want that the petitioner should languish in jail, anymore. Accordingly, she stated that the petitioner may be enlarged on bail. Regarding head to the period of custody for the petitioner since 23/4/2024, and the fact that the victim had given an affidavit in this court, inter alia, requesting this court to enlarge the petitioner on bail. I am inclined to admit the petitioner on bail accordingly. Yes. 58.
The last occasion, the lawsuit directed the state to bring this CD.
CD is there?
The CD is there, my lord.
Yes. Ready?
Yes, my lord. But one thing is there, my lord.
So for my instruction is concerned, my lord, in the meantime, SC/ST Act is added. Therefore, my lord, this petition should have been as a CRLA instead of a BLAPL because it is under special statute. So if your lordship pleases that, then registry may be directed to convert it to CRLA.
Why don't you renew your bail there? See, you, when the charge sheet was filed? Charge sheet filed on?
No. My lord. My lord.
Date of charge sheet.
My lord. Regarding charge sheet, my lord, the only CD is there, my lord.
When the charge sheet was filed?
I don't have an instruction also. If it is converted to CRLA, then
no, I will not convert it.
My lord, I may pardon, my lord. Yesterday night I have gone through properly, my lord. I have obtained the CD, but that CD is not up to date and complete.
Charge sheet is filed or not?
No, my
Whether
lord.
charge sheet is filed
I have to take
after
instruction.
May 2024 or what?
I have to take instruction, my lord.
You also may grant me
Last CD, just see, last CD, the last entry in the CD.
Last entry, my lord.
Date.
Liberty may be granted to renew my prayer before the concerned court, my lord.
That's what I just recorded.
That would be better, my lord.
That's better idea.
Yes, my lords.
Yes,
right. A petition is agreed by the order dated 18/5/2024, whereby his bail plea has been rejected. Subsequent thereto, the charge sheet has been filed. In the changing circumstances, petitioner seeks to renew the bail plea before the trial court. If such bail plea is moved, the same shall be considered within 15 days on the basis of the available material forms part of the charge sheet. Yes. Next.
Gratefully, Lord, sir.
59.
Yes. 59. Non-appeals for the petitioner in the interest of justice adjourned to November last.
CD and 164 is there.
60, my lord.
Yes.
Here, my lord, though the petitioner inside the custody 14/12/2023. 14/12/2023. And in the meantime, the victim girl, my lord, examined at PW2, running page 16, annexure 2. Annexure 2, kindly have a glance of her deposition. Paragraph 7 and 8 and questionnaire format, the deposition are there. Running page 16, paragraph 7.
Come to the relevant part. Yes.
Yes, madam. My family members had no willingness for my marriage.
Where are you reading?
Page 16, paragraph 7. Annexure 2.
16, huh? Yes. Yes. Paragraph 7.
7. My family members had no willingness for my marriage with A1, although I was in love relationship with A1 petitioner and I wanted to marry him. There was no relationship between myself and A1 during the period of my stay with him. After my leaving my house, till police brought me to Narayanpatna police station. Accordingly, court may not declared as hostile, and she stated that she has no sexual relation with the petitioner.
She has not supported the prosecution. Victim.
Item number?
60.
60, my lord. In item number 60, my lord. That was sent, but this is a matter of 3763, my lord. Regarding the notice, there is no information whether
Yes,
notice has been
notice is
served or
the-
not,
that is the-
and
that is
CD is not available.
Notice.
ସେଟା ଥ୍ରୁ ପୋଲିସରେ ଏକ୍ସଟ୍ରା କପି ଦେଇଥିଲୁ 25 ତାରିଖ ଦିନ ଯୋଉ ଦିନ 21 ରେ ଅର୍ଡର ହେଲା 25 ରେ
CD is required, my lord.
Yes. Call for the CD and serve the informant.
Yes,
Public informant of the victim.
Informant victim ne, informant
Through the IO. Through the IO, release the matter after just 1 week.
ଗୋଟେ extra
In
copy
view of these two sentences,
Yes, yes.
in paragraph, he is entitled. Only the formality has to be complete.
Only my
Call
lord.
for CD and
Positive,
serve her.
I will serve another extra copy ଗୋଟେ ଦେଇଥିଲି
Please do that. Please do that. Yes.
61.
And that 2 paragraphs show him. That's enough for you. That's enough for you. Yes.
May I please your lordship?
Yes, madam.
The case is under my lord. It's between 666, 376 and
Help her.
664. So act, my lord.
Mr. Ponda, help her. Yes. Yes, madam.
My lord, the boy is of 18 years and the girl is of 17 years, my lord. They are both from same village and same community, and they are custody since 1524.
A short 164 statement is there, my lord.
Yes.
May I read, my lord? ଗତ 23/3 ଅଜୟ ମଣ୍ଡଳ ମୋତେ ବିବାହର ପ୍ରଲୋଭନ ଦେଖାଇ ବ୍ରହ୍ମପୁର ନେଇଥିଲା ଓ ସେଠି ଗଲା ପରେ ଖଗେଶ୍ୱର ଲଜରେ 4 ଦିନ ରହିଲୁ। ସେଠି 4 ଦିନ ଭିତରେ ମୋ ସହ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା।
May it please your lordship. The petitioner is in custody since 21/1/2024. 21/1/2024.
My lord,
Charge sheet has been filed on
my lord,
17th.
I'm sorry to say, my lord, that letter has sent. It's a matter of 304B, my lord. CDS.
306.
Any short date, my lord, maybe.
May I pray one thing, my lord? The connected matter is there, CD may be available in this.
What is
The
Let both the matters be
खाली मत
listed
number
tomorrow,
टा
my lord.
मत अग्रवाल बाबू खाली number टा कटे कोई
Then constable petition submit that there is a connected matter pending before the this court. BLAPL number of 5830 of 24. Please the matter along with this matter next week. Yes.
Tomorrow.
Tomorrow will you come?
You are come. अग्रवाल please. अग्रवाल please मत खाली दे BLPL.
Yes. Next.
May I be? Well, the petitioner is in custody since 16/12/2023.
16/12/2023.
Alleged offense under section 419, 20, 465, 467, 468, 471, 120B of the IPC.
May I pray one thing, my lord?
Yes.
It's a matter of state task force, my lord.
Sorry.
And task force matter, my lord.
Uh-huh.
One of a doctor, state task force. Doctor has illegally business activities in at Jammu for illegal business, forged documents, and etc. Many things are there, my lord. My lord, I have not gone through properly, my lord.
Next week.
My lord.
66. 66. One Passover.
Passover, midnight Passover.
Only one Passover.
Next week. Huh? Next week. Next week. Yes.
67.
Inconsistent. Inconsistent definition subject of
68.
Yes.
67.
Influxes.
Yes, may I please Joseph? The petitioner in custody since 18/11/2023, my lord.
18/11/2023.
2023.
Okay.
Their date of occurrence is 8/1/2013.
8/1/2013.
FIR on 9/1/2013. Then charge sheet filed on 9/12/2023. Lord of C, kindly come to that page 22
After
of the
10 years.
Yes. Lord of C, kindly come to page 22 of the charge sheet.
2013.
I'm a local inhabitant. Lord of C, page 22 of the charge sheet, that operative portion, my lord.
What is the offense by the way?
Yeah, 302
147,
141, 148, 342, 149. Read it 25 points of Arms Act and 17 of
Yes,
Criminal Law Amendment
yes.
Act.
Let us see the charge sheet.
Yes, you'll also see page 22, the operative portion. Second para, may I please? During page 22, para 18, the second para, may I please? During course of investigation, that from 1, 2, 3, 4, 5, 6, 7, 8, 9, para, second para, the 10 number lines. You also got it. During course of investigation, it was ascertained that the accused Rupchand Majhi and Pavitra Majhi. Rupchand Majhi already granted bail since 2013. And Pavitra Majhi of village Potpani had instigated the band Maoist to kill Chaitanya Majhi, branding him to be a police informer due to previous dispute. Sin accept this.
That's what.
Yes.
Your friend has been granted bail on
Since 2013.
So then you were absconding the what?
No, I'm not. I'm the
They
local
will come to your
inhabitant.
house to give you bail.
I'm local inhabitant, my lord.
He was absconder, and what he has done, my lord, due to previous enmity, he has created a rumor that the deceased is a police informer. And for that reason, they engaged the Maoist, they have, my lord, killed the deceased, and some of the witnesses also stated that.
There is no evidence that we have instigated, my lord. You'll see.
How many witnesses are there?
In the charge sheet,
Eyewitness.
2013 matter, my lord, it was.
There is
not
yet to
properly
commence.
legible. 161 statement is not properly legible, my lord. But I have collected two statement.
No, I want to know how many eyewitnesses. Let the
No,
eyewitness.
total 21.
Govinda, my lord.
Total 21 number of witnesses. Trial is yet to commence.
That's right, but I want to know how many eyewitnesses, material witnesses.
No eyewitness to the occurrence.
Material witnesses. What are
No,
the
nobody is there, madam.
ଯେ ଆଜି 7/2/23 ପାଟପାଣି ଗ୍ରାମର ଗଗନ ମାଝୀଙ୍କ ପୁଅ ଟଙ୍କଧରି ମାଝୀର ବାହାଘରକୁ ମତେ ନିମନ୍ତ୍ରଣ ଦେଇଥିବାରୁ ମୁଁ ପାଟପାଣି ଗ୍ରାମକୁ ବାହାଘର ଦିନ ଭୋଜି ଖାଇବାକୁ ଯାଇଥିଲି। ଭୋଜି ଖାଇ ସାରିବା ପରେ ଅପରାହ୍ନ 4:30 ସମୟରେ ମୁଁ ଏବଂ ଚୈତନ୍ୟ ମାଝୀ ପୁଅ ମିଶି ତାଙ୍କ ଜମି ଆଡକୁ ବୁଲିବା ପାଇଁ ଯାଇଥିଲୁ। ସେହି ସମୟରେ 20ରୁ 25 ଜଣ ଲୋକ କଳା ରଙ୍ଗର ପୋଷାକ ପିନ୍ଧି ସମସ୍ତେ ବନ୍ଧୁକ ଧରି ଆମ ପାଖକୁ ଆସିଲେ ଓ ଚୈତନ୍ୟ ମାଝୀକୁ ତୁମେ पुलिस को माओवादी के बारे में खबर देते हो कही तार दुईटा हाथ को पछपटे गामुछारे बांधी दे बाड़ी रे बहुत माड़ कले एवं बंधुक चैतन्य पेटरे गुड़ी मारिदेले आखिरे छुरी भूसी आहुरी गुला गुला करी मारिले मारी दे सारा पर माने माओवादी लीडर कहले मनोज सुनीता रवींद्र एवं अन्य नाम धरी चलो काम खत्म हो गया कही चलीगले भयर से मुझे पलि आसली मुझे पाइल जे पाटपाणी ग्रामर रूपचंद्र और पवित्र माझी सह प्रेजेंट पिटिशन चैतन्यर सह पड़ ना तेणु पवित्र रूपचंद्र माओवादी को डकाई चैतन्य को मराई।
On the date of occurrence, admittedly, neither the person was present.
The FIR was registered, the incident pertains to 8/1/2013, whereas the FIR was registered on 9/1/2013.
Against unknown.
Against unknown person.
Yes.
9/2/90, 9/1, 9/2/30.
9/2/30. FIR was 9/2/30. The petitioner was stated to be absconding, therefore absconded, and subsequently he was apprehended on 18/11/2023.
23.
And then also for the petitioner submits that the co-accused, what is his name?
Rupchand Majhi.
Was apprehended and was granted bail in the year 2013 itself.
Yes.
2013.
May I give the number, my lord?
30. Since the petitioner was absconding, but however the petitioner was absconding. Regarding to the nature of the allegation made against the petitioner, I am not inclined to enlarge the petitioner. However, the petitioner is granted liberty to renew the bail plea before the trial court immediately after the material witnesses are examined. The trial court is directed to examine all the material witnesses preferentially over all formal witnesses. Like the petitioner is also granted liberty to renew the bail plea after 6 months if for any reason the material witnesses cannot be examined by that time. If such bail application is moved, the same shall be considered on the basis of.
So within 3 months that metal witnesses are to be. In fact,
yes,
on the date of occurrence, I was not there. Save and accept the confession
These are Noxlite activities. The manner in which he was killed.
No, at the instance of the
Tied
nocturnal,
the hands
I
on
am
the
not
back.
there. On the date of occurrence, I was neither present
But
nor
it is-
I have in
it
the
is
role.
you and
Only
you-
allegation is that I've aided and abetted in.
It is you and the other guy you have informed my moist that he's the guy who is giving
Police
information.
The other
Therefore,
accused,
all of them came
the
and
other
were
accused
killed
who stand on similar footing already granted bail since 2013, my lord.
because he was. Why have you absconded? Why should the court?
I'm an inhabitant, a local inhabitant. I'm doing my agriculture work.
Local inhabitant police will not arrest.
For 10 years, I will abscond, my lord. My entire family is there within the village. For 10 years.
You should have surrendered. Why have you not surrendered?
Charge preliminary charge sheet monare nothila. Subsequently, final charge sheet monare asila. And charge sheet file after lapse of 10 years.
The highest activity. Yes, next.
Lordship, 3 months that.
Next time. Huh?
69.
Lordship, 3 months that
No.
after examination of the material witness, I'll.
No, whichever is earlier. It may be 1 month also.
No, trial is yet to commence.
I have given direction. Yes.
69.
Next. Mr. has mentioned.
My lord, 69, Mr. Devashish Ponda is to appear in this case.
Adjourned on request. On request.
My lord, in this case, what happened, the one similar matter. Though they are giving some forged document and obtain the bail application. For that reason, this honorable court has taken this bill. In BL appeal number 6107 of 23. So my claim, my lord, that let this matter be heard by this coordinate bench. Because
I didn't follow. What?
My lord, this the matter is that, my lord, that the present petitioner has given some false document and obtained bail order. For that reason, this case was
Another case registered.
My lord. That court has, my lord, in the annex 4, my lord, kindly say, this court has taken that view that though he has given some false document and let this matter be heard by that bench, my lord.
This is up to November will see. Entering. The wife of the
Only 201. He present only
CD has come on. CD has not come?
No, man, CD has not.
But 302 is also there. It may not be made out against you, I don't know, but since 302 is there, at least CD should come. Otherwise, how can I?
Principal language was made 302 up to 2015.
You must be absconding.
2015 matter.
You must be absconding.
Yes, you submitted 2021.
At least the formality should be completed. Charge sheet should come, thereafter I'll grant you bail. The last opportunity, yeah? And after 1 week. Let the charge sheet CD come. Yes.
72.
Sorry?
Bring application also.
Yeah.
73.
It is
376 CD.
CD. Call for CD. Yes.
74.
74.
74 also 56 gram brown sugar.
My lord, 74, I'm appearing through VC, my lord.
Yes.
Yes, my lord, 56 grams of brown sugar, your lordship's normal order of passing any orders with antecedents, my lord.
6 gram, but CD is not enough.
My lord, with antecedents, your lordship may kindly pass.
Custody since?
Custody, your lordship will kindly have the first date, that is 10/6/2024, my lord.
10/6/24.
Your lordship.
10/6/24, 56 gram of brown sugar. Yes.
So grateful, your lordship.
75.
Yes.
75, my lord. Appearance memo to Mr. Devashish Ponda is signed.
My lord, I am there virtually. 75.
Yes.
My lord, the petitioner is the husband He is in custody since 12/1/2024, my lords.
12/1/24.
My lords.
Yes.
The allegation is that his wife died, my lords, by committing suicide inside a locked room.
Show me that portion.
Yes, my lords.
Show me that portion.
My lords. The statements on record, my lords, establish that. If your lordship will see the statement of Raghavendra Kumar, he has stated that कल 10-1-24 शाम को मेरा समधी अनिल कुमार सोनी फोन करके बताया कि मेरा बेटी आत्महत्या कर दिया. This is the informant, my lords. Then, my lords,
It's not placed, man. Not placed. So, the two vendors made application, they are the two vendors application. Both are not placed. সব item one. Yes.
28.
You have to do the application. 1.2 21 to 24. 21 to 24. Yes. Petitioner is 22 months. Yeah. Petitioner is 22 months. And victim from implement is 18 months. Yes. डिसेम्बर मासरे गर्ल्स हाई स्कूल रे पाठ पढ़ुले मु डिसेम्बर छुट्टी रे दरखास्त दे घर को जाइथिली छुट्टी रे मु बाजार को आसिली आसला समय अनंत बोली पिला मोर भेट हैला मते मते इच्छा करली एवं नेबी बोली कहिला तापर मु सांगर तांको गां को गली सेठार मते तांको घर को नेला सेठार से मो सांगर शारीरिक संपर्क रखिला सेठार मु तांको सांगर मासे रहिली तापर मते मुनिगुड़ा नेला सेठार गोटे दिन रखिला तापर लॉज रे सेठार मध्य मो संगे शारीरिक संपर्क रखिला तापर दिन आमे घर को फेरी आसिलु सेठार आमे 10-12 दिन रहिलु एवं मु गर्भवती अछि किंतु से पिला कहूची मते नब नाही तापर मु रिपोर्ट देली.
Yes. What else? What if status he will not marry? She gave birth to a child.
No, man.
He says that I am pregnant.
Yes, she was pregnant.
That's allegation, man.
What allegation?
Medical.
Medicality, they are pregnant.
Is she pregnant?
Yes, sonography is there.
Huh?
Sonography pregnant is there.
See, read evidence, medical evidence.
But the only certain, only positive there. This is the things I heard. Not possible only here is written positive is there only. Because it is not visible properly.
Get proper instruction. She is pregnant, then it's a different story. Next week, huh? Next week. Get the instruction.
29.
Lady of 3 years, my lord. 5/3/2024, my lord. 5/3/2024, my lord. Yes, 55 kilo of ganja has been seized from the house of the petitioner. How much? 55 kilo of ganja. Yes. CD is there.
Yes.
CD has come. Criminal antecedent? No criminal antecedent.
70. Not subject to criminal antecedent. Antecedent is not here.
Custody 5/3/2024. Recovery 53 kg of 55 kg of contraband ganja. Recovery.
Mr. Mishra's name may kindly be deleted.
Oh, sorry?
Mr. Mishra's name may kindly be deleted.
You're finding a fresh one.
The brief has already been transferred.
I'm not able to hear you.
The brief has already been transferred.
Okay. Name of
Mr. Tanmay Mishra and Associates may
Tanmay
kindly be deleted.
Yes.
May it please, Lord. Lords, here the petitioner has been arrested on the ground that he was trying to avoid summons, my lords. My lords, 28/6/21 summons was issued to him and he was suffering from COVID. He prayed for some time. Thereafter, 12/8/21 to 22 had the ED had issued subsequent summons to which the petitioner had replied. Thereafter, he had gone to Dubai, my lords, to be with his son, and was there for some time, my lords. A lookout notice was circulated, and when he came back to India, my lords, he was arrested.
Arrested on?
Arrested on 18/5/24.
Yes.
By the ED authorities. Initially, my lords, he had also moved for anticipatory bail before your lordship, but as your lord, this honorable court observed that as there is no apprehension of arrest, so you can go out on bail.
Yes.
There is no necessity of granting you bail. Now, my lords, the sole ground for which the ED was looking out for him or has arrested him is because he was trying to evade the process. Now he has been arrested, his statements have been taken, charge sheet has already been submitted. And my lords, he in the vigilance case, which is the scheduled offense, he has already been granted bail. My lords, so under the circumstances, when the statements have been recorded and when, my lords, there is no necessity of keeping him any further behind bars, my lords, and whatever is there, my lords, has already been recorded. And he's behind bars and charge sheet has been submitted. The entire investigation is complete. It's also complete with the vigilance authorities.
In scheduled offense, you got the
In scheduled offense, we have
given a copy.
Yes, Mr. Global.
My lord, it's not that simply someone were issued and he has not cooperated, so he has been arrested. My lord, on 22/9/2009, FIR was registered under section 13(2), read with 13(1)(d) of PC Act, section 420, 379, 120B of IPC, and section 21 of Mines and Minerals Act.
He got the bail there.
That I have no instructions, that I have put it, might be.
Yes.
My lord, so accordingly, ECIR was registered, investigation was carried. What is the allegation? Your lordship, kindly see the allegations.
Allegation there.
There are 3 accused, my lord. Out of 3, this accused and another principal accused who has conspired along with him, Pratap Kumar Das, he is still absconding. He is still absconding. He moved for anticipated bail before my lord. Your lordship has rejected, directed him to surrender, but till date he has not surrendered. Now, your lordship, kindly see your lordship, kindly see page. They have filed a bunch of documents on.
You said Pratap Kumar Das.
Pratap Kumar Das. He is still absconding. No, PCR I cannot say. In our ED case, in this case, still absconding. He moved for anticipatory bail. Your lordship, after hearing reject, directed them to surrender and move for bail. But till date, he has not said. That date has gone since 2 months back. Your lordship, kindly see they have filed a bunch of documents. In that bunch of documents, they have filed the charge sheet we have filed. My lords may kindly see page before granting.
Is there any flight risk?
Yes, my lord. Now, multiple summons were, your lordship, kindly see page 22 of that charge sheet. How many summons have been issued? I have also.
He is resident of Dubai.
He is resident of Calcutta. After getting summoned, first he has not appeared, COVID different. Thereafter, twice he was again issued summons. He said, I am not well, I'll come on this date. That date he has not come. Thereafter, multiple summons were issued. He fled away to Dubai. And the important thing, my lord, he has given the address, the company, registered office of the company is the forged address. In the other people's name, he has created ID and
bank accounts has been opened by a forged ID. More than 300 crores has been siphoned off of the bank. Bank has declared NPA. Bank are not getting it. Your Lordship, kindly see page 22.
22.
Yes.
These are not the allegations. here.
Yes, yes, these are allegations.
These are not the allegations.
Yes,
here.
yes, you read my counter. I've given in my counter.
In the charge sheet, I'm talking about the charge sheet.
Yes.
Page 22. Lordships.
22 of your objection.
No, my lord. Page 22 of charge sheet. They have filed on 6/8/2024 with a memo.
I think it will take little time.
Yes,
Yes,
sir.
Fine, huh?
Yes.
Little time. Let it be Tuesday or Wednesday. Tuesday or Wednesday.
Except Thursday, any day convenient to my lords.
Tuesday or Wednesday. Wednesday.
At about.
But you think of how to ensure its presence.
My lord, it cannot be. All IDs, I will point out, my lord, all bank KY account open KYC are all forged.
But those are all evidentiary,
My lord,
documentary
there is
evidence.
a flight
You
risk, my
collected
lord.
everything.
He has wind up everything from India.
No, I'll surrender my passport, my lords.
Whatever conditions you need, see, all these for whatever he has done, all are documentary evidence.
That's true.
Documentary evidence you have collected.
Your lordship is to consider the conduct of the accused, my lord.
For that, to whatever condition you want.
No, it's not the question, but your lordship must see the conduct of the accused also.
But the idea is to see that the proceedings should go on uninterruptedly. He has to appear every day. That is the whole idea.
Yes, my lord.
So you tell me
Not only that, my lord, now it is a preliminary stage. Now we have filed preliminary charge sheet. Other accused has not been arrested. We are not able to record statement of other persons because of non-cooperation of these accused persons. Matter is pending since 2013.
No, one of the co-accused person is absconding doesn't mean that he will
the rest will suffer.
No, that's not absconding. Because we are not able to record statement of all the accused persons. We have to trace the money trail, my lords.
But the statement of this witness, this
we have taken on remand, we have recorded. This witness,
you need further remand.
That I have to take instruction. I'll take.
Already charge sheet is
If you
also
need
submitted.
further
No, it's a preliminary charge sheet. That has to be filed.
See, the problem is one of the accused is absconding. They apprehend that accused. They will take his statement. If some link is there, then
No, there are links, my lord. There are materials. These two persons has connived with the original mining lessee.
You make all sorts of allegations, I understand, my lords. But if a person absconds and it doesn't turn up, the prosecuting agency fails to apprehend him. For that, should a person who has come back,
what I am trying to say is,
yes, Paul.
Your custody may be required at some point.
At any point.
I'll tell you why. What happens is, if the co-accused who is absconding, he is apprehended tomorrow, and he was his statement is recorded. Something comes out. They want to confront.
It's always that your lordships can ensure. And even otherwise, my lords, just to apprise your lordships, my lords, if his intention was to avoid the process, he would have remained back in Dubai, my lords.
His intention was to avoid. He had come for some other purpose. Because of lookout circular, he was arrested. He has not come to join the investigation.
Think over that. How to ensure his presence in the trial as well as further investigation under 173A.
Yes,
these two things we will have to ensure. For that, what you want, you tell me.
Yeah,
you can't keep him.
No, it's not the question of my lord. The conduct of the accused is important. It's a serious offense, my lord. More than 300 crores of siphoned up of the bank.
That is not the
problem would be now the Kejriwal's judgment will come in.
No, it's not a problem, my lord.
There also 9 times he has ever. And then the court has now taken very.
In Kejriwal case, the allegation was limited. Here, not only he has cheated of the illegal mining, he has also cheated number of banks, my lord.
There he got bail.
No, my lord. That bank. Only in PC case he has got the bail. I have to take instruction also on that. What step they have taken.
You take a copy of it. Give it a copy.
I'll serve a copy.
Please save the copy.
Yes.
And
Wednesday. 2 p.m.
2 p.m. Wednesday. Yes, Mr. Agarwal, do you have any problem?
Lord, one election matter has been fixed, your lordship.
Well,
He doesn't want to leave paid
Friday.
brief.
Well, he assists me in all election matters. Any election
But in
matter
any
which
case,
comes
but
to me, I give it to
he
him.
will not sacrifice the paid brief like this.
No, I will not sacrifice both, my lord.
Let me and then Thursday.
Thursday I have a problem.
He goes to Bhubaneswar.
Let it be Friday then.
Friday?
Friday.
Friday, 2 o'clock. Friday. Friday there would be a reference.
Then your lordship may keep it on fast.
Monday.
Monday?
Already in class.
Next Monday.
A Monday, coming Monday, or subject to your
Tuesday,
lordship.
keep it on Tuesday.
A Tuesday?
Tuesday.
Coming Tuesday.
Yes,
ठीक है.
First.
Yes.
81.
81.
Oblige.
The allegation is the 419 and 420 of IPC. See it. The allegation is the against me was that
498A
no, 419, my lord.
and 420.
My lord. The admittedly the informant, the complaint is and the present petitioner was in following law in each other, and thereafter the incident happens. The incident that we has alleged that making loan in her name by using the Google account and other fake account, Facebook account, and most of there is no case lodged in the in accordance to IT Act, and investigation is completed and charge sheet has already been submitted.
Charge sheet filed for which offences?
This 419 and 420.
420.
My lord.
Yes, Mr. What?
My lord, another place where I want to draw
Custody
the my lord.
Custody sins.
Constitutions 10/4/2024.
Okay.
But another one line I want to draw the attention of this court that the rejection order second page, my lord, page 8. The Learned JMFC is directed to dispose the case within 5 months from the date of receipt of this order. 3 months already passed, but not yet charge has been framed.
Who has given this direction? Trial
Sessions Court.
Sessions Court.
Additional
What are the exact
testimony.
allegation? Let us see. What? What are the exact allegations?
Petitioner has created the fake ID in name of the informant, and also he has taken the opened the bank account in the name of the informant and taken the loan in the name of the informant.
What is the loan amount?
Loan amount one is 77,000, and another is 98,000. HDFC Bank.
420 and 419. Only.
Yes.
Where is 468, 471 and all?
Because although no photographs of the informant he has.
No, why have you not implicated him for other offences? Why 420 and 419 only?
Otherwise, the document is also there. The photographs also is there.
Why have you not done it? That's what I'm asking.
That's what it is not
If
there.
everything was there, you should have booked it for other offences also.
Yes.
You have filed charge sheet under 420 only. 419 is the definition section.
120, 384.
Huh?
384.
384. If the allegations are such, then it should have been other offences also. Yes. What do you say? What do you say?
Yes. Although the accounts, he has taken the loan in the name of the informant, those documents are also there. And although the amount also he has taken away, that is also there.
But loan.
77,000.
And he is threatening to.
77 and what is the amount? 77,000 and?
77,080, 98,000 and 77,000.
You have implemented that informant. Bring the informant. Huh? Next week. Let the constable the petitioner seeks to implead the informant in the present case as opposite party number 2. Issue notice to opposite party number 2, list the matter. Bring her. We will try to settle it out. For completely quashing the matter. Because the allegations are not much serious. It looks like.
No doubt, there
your
is the-
investigation
for
is
that
also
reason,
such.
yes, no doubt
Only
about it, but
420. What is
they have
420 is not
collected
made
all
of.
these photographs also, they have collected, they have
Nothing.
got the ID.
So collected, why have you not filed charge sheet like this? You see the charge sheet. Charge sheet is nothing. He is entitled to bail. The only I'm thinking of settling the dispute by you. Get ready to pay and finish it up.
Well, my lord, I am in custody. I am the already gave the money to the informant by selling my land also. So I have no money now. At least some time I
You
may
have
be
paid
required.
the money already. Show me.
No.
Yes,
Before the incident, I paid some money by selling my land for the purpose of business, though which is in the name of the informant is the proprietor of the said business. So I gave him money. So now at least I lost my job. This is the outcome of law of affairs.
I'm granting bail.
No, Lordship, it will keep at least, if
So any
implement will
terms and
come,
conditions?
and then any settlement will there, it will be better, Lordship.
Friday, coming Friday.
So, my lord, I am suggesting, subject to application, let me also go on bail, and after some times I may be able to
Then nothing is-
condition may be imposed that so that I will appear in police station. After 2 to 3 months, I may be able to something.
I think only if she will
Each and
appear,
every
nothing is there.
When the
weekly once.
charge sheet is only 420. That's the whole difficulty. I'm granting bail with all conditions.
Or Lordship, keep at least mediation, at least they should
I'll
go.
send it to mediation.
Yes.
And allegation against the petitioner. After investigation, charge sheet has been filed for alleged offence under section
490.
380. Or 19, 420, 380.
419, 420, and 380.
384.
384. 384. When it comes for the petitioner submits that the informant was the business partner. His business.
No, proprietor.
And see the proprietor of what?
R&A Rubik Electronics.
Electronic. Proprietor of R&A
Rubik Electronics.
And the present petitioner
Both.
invested the money in the proprietorship concern of the informant. Due to misunderstanding, the present case has been filed. He is in custody since 10/4/2024. He submits that once he is released on bail, he will be making all endeavor to settle the dispute with the informant. Regarding head to the period of custody and the nature of allegation against the petitioner, I am inclined to enlarge the petition on bail, subject to condition that the petitioner, after being released, shall participate in the mediation process to be initiated in the High Court. High Court mediation. High Court mediation. Release and bail law, put the condition law. The parties are directed to appear before the mediation center for exploring mediation, and the coordinator of mediation center shall issue notice to the petitioner as well as the informant in the present case, fixing a date for exploring the possibility of mediation.
And restriction for that, Google he has created by name of the informant, and they all these fake nude photographs. He's living, that is Instagram, Gmail, and he's hacking the ID of the informant.
Where is the offense you have
Obviously that is there.
implicated him for ITA?
But it is there in record.
There, then you should have implicated him. Only 420.
For that, I am saying the restrictions should make.
Restrictions have.
Yes.
What restriction I can?
That's fake ID. He should not create in the name of an informant.
He has already done it. He has already done it. What you are supposed to do, he has already done it.
At least,
and you know that being police, you have not. Those allegations are there. Materials are there, but there is no charge to that effect. Only you file a charge sheet for 420. If you file a charge sheet for 420, why should he be in the jail? Because if you are wrong, he is in custody in 10/4/2024. I am only sending to mediation because it appears that they are business partners or something might have happened. problem.
83.
I have you kept the further investigation open under 173(8)? Just check it. The last paragraph of the charge sheet.
That's it. Charge sheet actually. Charge sheet ko
Charge sheet last line.
Last line it look.
charge sheet ariye CD run charge sheet.
No.
Next page.
No, 90.
Nice, rich.
9. 490 to 420, 384 of IBC. Oh, my lord.
Open it.
Keeping the investigation upon as per the provision of 176(8). It's not issued a bank statement, say, and other documents, KYC forms. For that means say persistent not.
How to continue since the investigating agency has kept the further investigation open, the petitioner is directed to cooperate with the investigation as and when he is called for by the IO. Okay. Okay.
Petitioner is in custody since 34/24. 34/2024. 2024.
Okay.
Allegation under section 21B of NDPS Act.
How much recovery?
200 grams brown sugar. My lord, the mother and son.
CD is not come.
My lord, CD, your lordship may kindly see on 27/6/2024, CD was called for. And as on date, no CD.
Last and final opportunity, CD. Without CD.
Mata gote date diyantu.
Date. After one week, date. After 1 week. Last and final.
Asara pare na. Nahi, chutti pare nahi hai.
On 27, no, I'm just writing it down. On 27/6/2024, this court has directed the petitioner state counsel to obtain the case diary. Learned counsel, Mr. Rahul, the counsel for the petitioner seeks for that time. By way of last opportunity, one more opportunity is granted to obtain case diary, release the matter.
On 27?
Oh, give it. Can you get it by that time?
Yes.
27. Yes.
Oblige.
84.
My pleasure, Lords. Open under section 395, 120B, 412, 459 of IPC, radio section 25, 27 and 7. Petitioner is in custody 14/4/2020.
Two accused?
Yes, my lord. I am appearing the first item. I seen.
Item.
Yes, sir. Custody since?
Custody 14/4/2024.
15/4.
4.
14/4/24. 15/4/24.
Okay. Yes. Offenses?
395, 459, 120B, 412.
Armed act and all.
25, 27.
Yes.
Answered.
Yes.
Seizure is there, Lordship, all has been recovered, and 7 antecedent is
And
credit of the both of them.
File affidavit, both of them.
yes,
Regarding your antecedent, file it.
File.
Right, learn counsel for the submit that they will be filing an affidavit detailing the antecedents and the status of those cases. At least the matter of tomorrow.
My lord, that's a.
Yes.
The accused persons are young boys of their 20s, early 20s, 26, 27.
But your Lordship will
And they are
see.
already sufficiently punished, my lord.
You file an
Yeah.
affidavit.
Hello?
You file an affidavit regarding your antecedent, giving details. What is the stage, whether you got the bail or not, and all. Complete detail.
Oblige. Both the cases, sub cases.
Both the cases. Yes.
my lord, fixed it to
83,
85.
85,
85.
85.
May I please, your lordship? Arising out of a protest petition, the petitioner is in custody since 17/5/24. My lord, co-accused has already been released by my lord.
Offense?
Offense 302.
302.
302. So initially, FIR was filed. They filed a petition to send it to for investigation to crime branch. Crime branch took up the investigation. They filed it.
CD is not. Charge sheet is not there. Charge sheet is not come.
Not required, my lord. CBI CD took over the investigation. They filed the final form.
Closure report.
Closure report. Thereafter, they filed the protest petition. Under protest petition 202, after 202 inquiry, cognizance has been taken. Out of 6 witnesses, 4 witnesses has already been enlarged on bail by my lord. I have already given the order.
Let's see. What are the allegations against you?
Nothing else is.
Because my lord, they arranged one subsequently one case for that is your lordship issued notice to the opposite party. They had already.
I am appearing for the informant.
For that is in the case, sir.
What do you want to say?
Lordship, there is allegation against him that.
You simply tell what is the difference between the allegation between the these people. Ajay Kumar has been granted bail. Ajay Kumar and who else?
Ajay Kumar Barik and my lord Rajendra Ghadai.
Rajendra Ghadai. Is there any difference?
Lordship, this
The
present
allegation between this Kalandi Prasad.
this present petitioner helped him to take away the.
Are you prepared or not?
No.
Not prepared? Get prepared. Tuesday, huh? Let him prepare. The young guy.
Already they took time, my lord.
That's right, but see, you have to see co-accused person have already been granted bail. See, the problem with you is co-accused person has already been granted bail. This is the case arising out of a protest petition. After investigation, closure report has been filed. So he is entitled to bail. Since you are appearing, I am just adjourning to Tuesday, so prepare and argue. Despite all these things, can you oppose the bail? Only this much you tell me.
Yes,
Tuesday.
Grateful.
Yes, Tuesday. 86. Now you understood what
Yes, sir.
where you
86
stay.
also similar. 86 also
86.
similar.
Where you stand. Yes. No, same accused.
Same accused, my lord. Actually, out of one incident, 2 FIR was lost. PS case 26 and PS case 27. In both the case, the CBI CD filed the final form. It is a mistake of facts. Case of Downing. But later on, they have put up some witnesses who are not there before the police. And they are close relatives staying in the different village.
Their evidence under 202
202
recorded and cognizance.
Cognizance be taken.
Yes. Then I have a meeting. 4:30 I have a meeting.
That laptop matter, my lordship, keep it to Tuesday.
All these matters will go
Tuesday.
next. How many matters?
My lord.
Huh? About 20 matters. Spill over. All these matters will be spill over in the next.
Pass over also.
My lord, may I pray?
All the matters.
May I pray, my lord? Item 102 to 107. My lordship may send for mediation. The civil dispute out of arising of civil dispute, my lord. Opposite party, Mr.
Huh?
Read
They have to agree.
She's here, my lord.
You are ready for mediation?
We'll go for mediation, my lord.
Let's see.
Civil in nature, my lord.
Civil, for you, civil in nature. For her,
She knows very well, my lord. This is the civil case she has filed.
she doesn't know.
My lord, I beg pardon. 90.
All the matter will be taken up next week. All the matters will be taken
My
up.
lord, only I am trying to say is 93 items. Your lordship have put to mediation. The report has been waited and report has come. 20th to Ajibai Astila report. I need more time, my lord.
Okay.
2 weeks for
Mediation, awaiting mediation report, adjourned to 93?
93, my lord.
Yes. 93.
Obliged.
All the matter date will be fixed. Don't worry.
111 last hearing matter. I think my frame lord does this matter can be taken on board. But they have already talked to the Vigilance Council. They are prepared to.
Fourth. 101 na?
3টা ବେଳେ ଯଦି fix କରିଦେଲେ
101.
111.
Fourth. Yes, sir.
90.
It will be taken up tomorrow, next week. Item all the remaining matter will be spilled over to next week.
Item 108 I was mentioning, the opposite, my lord friend is also there. Either Monday or Tuesday.
Lordship, weekly list 169 item.
Let all the bail matter will be most probably over by Monday.
Yes, sir.
Thereafter, I'll start taking weekly. Let it be there. Yes, sir. Anything?
Sir, item number 90, where my Lawrence senior friend is appearing. No one.
So let it be next
Here
week.
the case is being adjourned, considering the pendency of the case of the co-accused before the apex court. Yes, I got the information yesterday. It was in the month of February and it has been adjourned. It has not yet been listed. I have got the copy of the order which I have downloaded from the
For last
website.
so many days, so many.
And they are also appearing, but they have also appeared.
Adjournments have been taken.
No,
there.
no, my lord may see. I'm reading the order passed by.
Your lordship may dispose of my I have filed for vacation of stay. Your lordship may dispose of that.
My lord, I am reading.
What is the order there?
Order passed by Honorable Justice Roy and Justice P.K. Mishra. The council, my lord, I'm not reading the name of the council who are appearing for the petitioner.
It is necessary.
Manan Mishra. Manan Kumar Mishra and senior counsel
He
appearing.
is a very dear friend.
Yes, I know that.
The council reads. The council reads the FIR. When I came, he was attached to my father. So whatever I have learned.
All of your secret he knows.
Whatever I have learned from him also.
So the tricks, he says that all these tricks is learned by.
The council reads the FIR filed by the second respondent, where she makes allegation of mental harassment by the petitioner who is claimed to be the informant husband. It is alleged that the petitioner during the subsistence of past marriage with the informant has got married to another lady. The affair is registered not only under section 494 IPC pertaining to second marriage during the subsistence of the past spouse, but also under section 498 of the IPC. The council would argue that cognizance should not have been taken under section 498A of IPC for a marriage which is over 3 decades old. Moreover, the offence under 494 is non-cognizable. To receive appropriate instruction on the contention raised, the Lord and Council appearing for the second respondent informant and the State Council pray for and are granted 4 weeks time.
This order is the last order is dated.
That is valid in the month of February.
So it will come up.
There is no interim order. Your lordship may dispose of my
Okay. Next week then. Monday, Tuesday. Yes.
ଆଜ୍ଞା 108 ଟା ଟିକେ ମଙ୍ଗଳବାର ନେଇ ଆସିବେ।